All right, ladies and gentlemen, welcome to the meeting of the Rutherford County Board of Commissioners. We'd like to call that meeting to order. We'll be led in prayer by Commissioner Turner. Then our pledge to the flag will be led by Commissioner Baum.
Thank you, Mayor Burgess. Real quick, I'd like to welcome Commissioner Cook back. We've missed you, and we are glad to see you back in your chair, and thank you for your service. Bow your heads with me so we can pray. Heavenly Father, thank you again for this opportunity that we've been afforded this evening to carry out the business of Rutherford County. We're thankful for Commissioner Cook. I'm glad that you were able to touch her body and allow her healing process to take place, and we're thankful for her and her service. I ask that you be with us tonight as we select someone from our community to serve in a judge role. I just pray that you give us clarity on our decisions, that you allow us to ask the right questions. Be with the candidates that have submitted their names. We're thankful for those who want to serve in our community. I ask that you bless each one of them and their families tonight. Watch over us this evening. Allow us to honor you and honor those who elected us to serve. And we give you all the glory. I ask these things in the name of your Son, Jesus. Amen.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Madam Clerk, please call the roll.
Commissioner Schaefer. Here. Commissioner Piercy. Here. Commissioner Jordan. Here. Commissioner P. Here. Commissioner Cook. Here. Commissioner Jernigan. Here. Commissioner Cush. Present. Commissioner Reed. Here. Commissioner Gurley. Here. Commissioner Turner. Here. Commissioner Allen. Here. Commissioner Stevens. Here. Commissioner Johnson. Here. Commissioner Baum. Here. Commissioner Nipper. Here. Commissioner Dodd. Here. Commissioner Phillips. Commissioner McAdoo. Commissioner Ely. Commissioner Gooch. Commissioner Sereno. We have a quorum, 21 present.
Okay, thank you, Madam Clerk. You can see that Mr. McCray is not with us tonight. We have Mr. Roger Hudson standing in with us. Mr. McCray has a very unexpected emergency, and he's not going to be able to be with us tonight. All right, so the next agenda item is reading and approval of the minutes. Mr. Phillips, please.
Thank you, Mayor Burgess. I've reviewed those minutes. I find them to be in order and move that we dispense with the reading and that they be approved.
All right, do we have a second? Mr. Sereno and others? Did anyone have any additions or corrections they identify? If not, all of you in favor of that, please say aye. Aye. Any opposed? Thank you very much. Next on the agenda is a resolution of recognition to be presented by Commissioner Reed on behalf of the Eagleville High School FFA chapter and land judging team. So Mr. Reed, please go forward. Do you want that group to come up here with you?
I'd like for that group to come forward at this time, if they would. As they're doing so, commissioners, you know how I feel about the diamond in the western horizon of Rutherford County called Eagleville, and I'm so excited about having this group here this evening. Reason being is the fact that you'll see those blue jackets that they're wearing right there, which represents FFA. And I want you up here. I want you up here, right here behind me. I have a jacket like that hanging in my office. It doesn't say that. It was back when I was in high school, and what we're recognizing this group for tonight with this resolution right here has to deal with the fact of some honors they have won. All of you know is this past Monday night, everyone was glued to their televisions trying to determine a national champion, and that was in football. These young people right here are getting ready to go after a national championship as well as their chapter has won a national honor also. They are a land judging team as well as an outstanding chapter that we have here in this county, and I wanted you to see this group that we have here, and we wanted to recognize them. Now, when I say land judging, it's very important that you recognize the fact of what they have to do this. Just as Alabama and Georgia did what they did after years of practice and hard work, this group did so too. They studied, they worked, they spent hours out in the field looking at soils, determining what they were, elevations. They also had to deal with science and seeing what is involved in that. And that's what agriculture is this day and time. It's no longer just cows and chickens. It has to deal with biology. It has to do with a little bit of everything. And that's what these young people are doing here. Plus, FFA is the future leaders of what we have in our county. So at this time, I'd like to read a resolution of recognition to the Eagleville High School FFA chapter and land judging team. Whereas on October the 30th, 2017, the Eagleville Land Judging Team won the Tennessee State Land Judging Contest held in Milan, Tennessee. And whereas the team members of Caitlin Benton, Kaylee Panetta, Kara Snell, and Carson Daniel, and whereas they were awarded the state championship at the 57th State Land Judging Awards Banquet, with Caitlin Benton earning the high individual score in Tennessee. And whereas they will now represent Tennessee at the National Land Judging Contest in Oklahoma City, Oklahoma, on April the 30th through May 3rd, 2018. And whereas the Eagleville FFA chapter was recently awarded the National Chapter Gold Star Award at the National FFA Convention held in Indianapolis, Indiana. And whereas Eagleville was one of only 5 Tennessee schools that earned this prestigious award, and this is the highest award a school can earn on the national FFA level. And whereas we commend Principal Bill Tollett and FFA advisors Bruce Haley and Emily Marshall for their dedication and commitment to these young people and for bringing this fine publicity to our community. Now therefore be it resolved by the Rutherford County Board of Commissioners that we extend this resolution of recognition to Eagleville High School FFA chapter and land judging team on receipt of these awards and wish them much success in all future endeavors. Resolved this 11th day of January 2018. Mr. Chairman, I move the passage of this resolution.
And second from a plethora of folks out there, Mr. P. and Mr. Jordan, I'm sure. All of you in favor of that, then please say aye.
Aye.
That is unanimous, and thank you and congratulations.
Mr. Haley.
On behalf of all of us, we really appreciate this. This is a great honor for us, and we appreciate you, Mayor Burgess, Mr. Reed, all the commissioners. We appreciate what you do for our county. These young people do work hard. They are very dedicated to what they do, and they just hope they bring a lot of recognition to the county. And we want to thank you for what you do for our schools. When it gets time for budgets and things like that, we appreciate that you understand that an education is not really, it's priceless of what an education can do for these students, and we appreciate you for it. Thank you.
Thank you. Okay, thank you, Commissioner. We don't have any public comments for tonight. So, Commissioner Turner, we're ready for elections and confirmations.
Thank you, Mr. Chairman. Commissioners, you'll find on your iPad a list of notaries that we need to approve, and I make a motion for their approval.
Second, Commissioner McAdoo and others. Any other nominations that we need here? If not, all of you in favor of that, please say aye.
Aye.
Are there any opposed? Thank you, sir.
Steering would like to also announce a vacancy on the Conservation Board, and that's our report for elections and confirmations.
Thank you, Commissioner Turner. Commissioner Phillips, a resolution to approve the consent agenda.
Thank you, Mayor Burgess. I've reviewed that consent agenda. I find all the items appropriate, and unless anyone wishes to remove any item from that consent agenda, I move that the consent agenda be approved.
And a second, Commissioner Jordan. Does anyone have something they wish to remove? There being none, then, please cast your votes.
Anyone that did not vote and wishes to vote, or anyone who would like to change your vote, you may do so now.
Record the votes, please.
21 yes, motion passes.
All right, thank you very much. All right, now we're ready to begin the reports from our standing committees. Commissioner Jordan, Budget, Finance, and Investment Committee.
How's everybody this evening? Hopefully we'll get out here in time for everybody to go get some bread and milk at Kroger. Everybody else, the free world's there. We've got item K1A, which is a general fund budget amendments. Be it resolved by the Rutherford County Board of Commissioners that the general fund be amended as follows. Fire and rescue, decrease unassigned fund balance, $25,000. Increase expenditures to other equipment, $25,000. That's for some new air tanks for the volunteer fire departments. And increased revenue, sale of equipment, $20,000 to part-time personnel, $18,570, and related benefits. That's taking the sale of two the fire trucks that were taken out of service and putting them into that line item. This is different from what we saw in budget. This has got the benefits pulled out separately. Resolved this 11th day of January 2018. Mr. Chairman, I so move.
Second, Commissioner Piercy. Any discussion? If not, then please cast your votes. Mr. Jernigan, do you wish to vote there? All right.
Anyone that did not vote and wishes to vote, or anyone who would like to change your vote, you may do so now.
Record the votes, please.
21 yes, motion passes.
Thank you.
Item K1B, we got ambulance fund budget amendment. Be it resolved by the Rutherford County Board of Commissioners that the ambulance service fund be amended as follows. Ambulance service, decrease assigned fund balance, $93,150. Increase expenditures, fines, assessments, and penalties, $93,150. This is for the Medicaid assessment, which we did 1/3 of last month. We held up on that to see how that was going to work, and we're going to get back almost a 2-to-1, I think, on what we send to them, so we're all in agreement with it this month. Resolved this 11th day of January 2018. Mr. Chairman, I so move.
And a second, Commissioner P. Any questions, discussion? Please cast your votes.
Anyone that did not vote and wishes to vote, or anyone who would like to change your vote, you may do so now.
Record the votes, please.
21 yes, motion passes.
Item K1C, resolution for the purchase of a North University Street building and related budget amendment. Whereas there is a need for additional office space for the drug, DUI, mental health, veterans, and co-occurring courts, and whereas the Property Management Committee in October 2017 authorized the county mayor to negotiate for additional office space for up to $1 million. And whereas a price of $1,100,000 has been negotiated for an approximately 10,000 square foot medical office building at 525 North University Street, Murfreesboro, Tennessee, on approximately 1.18 acres. And whereas the property would be subject to a negative report on a Phase 1 environmental study, therefore be it resolved by the Rutherford County Board of Commissioners that the county mayor and all other appropriate officials of Rutherford County, Tennessee, be and are hereby authorized to execute for and on behalf of Rutherford County the necessary documents to purchase property at 525 North University Street for a price of $1,100,000 upon receiving a negative report on a Phase 1 environmental study, and additionally that the general fund be amended as follows to provide funding for the purchase. Decrease restricted for capital projects, $550,000. Decrease unassigned fund balance, $555,000. Increase expenditures, building purchase, $1,105,000. Resolved this 11th day of January 2018. Mr. Chairman, I so move.
Second from Mr. Cush and others there. Any questions or discussion? All right, please cast your votes.
Anyone that did not vote and wishes to vote, or anyone who would like to change your vote, you may do so now.
Record the votes, please.
21 yes, motion passes.
Thank you very much.
Thank you.
Okay, we do not have a report from the Health and Education Committee or the Property Management Committee. And the next resolution is from the Public Safety Committee, Commissioner Schaefer.
Good evening. For your consideration tonight, we have a resolution to request the General Assembly to honor us with the privilege of having another circuit court position. Whereas Rutherford County is respectfully requesting the establishment of a new 16th Judicial District Circuit Court judge with secretary and appropriate funding for said positions. And whereas in support of said request, it can be shown that the 16th Judicial District, Cannon and Rutherford counties, had a need for 1.42 additional judges in fiscal year 2016, which is an increase of 0.25 full-time elected judges from fiscal year 2015. And whereas the 5 state trial judges in the 16th Judicial District hear approximately 11,000 civil or criminal cases per year, and whereas Rutherford County has a fast-growing population with the resulting growth in litigation and criminal charges, and whereas Rutherford County has the ability to provide office and courtroom space for said new positions in the new judicial building to be completed in the spring of 2018. Now, therefore, be it resolved by the Rutherford County Board of Commissioners to respectfully request, and by this resolution hereby do request, that the Tennessee Legislature establish a new circuit court position for the 16th Judicial District with secretary and provide funding for said positions. Be it further resolved that said circuit court judge position be established in sufficient time to qualify for the election in August 2018 for a 4-year term and thereafter be on the regular 8-year election rotation. Be it further resolved, the clerk of this commission is hereby directed to forward a copy of this resolution to the legislative delegation for Rutherford County with a copy to the Cannon County Mayor, received this 11th day of January 2018. Mr. Chairman, I move for approval.
Thank you, Mr. Stevens and Mr. Nipper and others. Any discussion regarding this matter? Okay, all of you then in favor of this, I'm going to let you please cast your votes because there is some money, but it's not that will be required if it happens. We'll have to furnish the law clerk. We'll have to pay for that. So please cast your votes.
Anyone that did not vote and wishes to vote, or anyone who would like to change your vote, you may do so now.
Record the votes, please.
21 yes, motion passes.
Right. It is 6:20, and we do have a public hearing that we'll have to hold at 6:30, so we have 10 minutes. And the next thing on the agenda is Steering Legislative and Governmental Committee. And I will address the fact that we have legal services agreement there. Mr. Schaefer, do you wish to say something before I get going?
For you to say, go ahead and get the news for Rutherford County on the way right now. And this was anticipated.
The what?
He wants to do these right here, sir. He wants to do the new.
He's not on, it's what we.
Oh, he
always-
wants to go any other business. Okay, excuse me for not catching on with that. But anyway, we'll hold on just a moment. We'd have one item, the legal services agreement. There is no resolution. There's nothing that we're proposing to say. Each of you have received a copy of an extended memorandum summarizing the history of this legal services agreement process from Mr. McCrary. He's not here to respond to anything you might say, but he's available anytime any of you individually want to call him or discuss that. And here's an opportunity for you to decide how you want to pursue this. In other words, we had a motion that was approved last time. Mr. McCrary has not agreed to that. He has given you some alternative discussion here. You can take it back to steering. You can wait for the full commission to discuss this next time. It's your choice. And you don't have to, if you don't do anything, I'm going to put it back on the steering committee's agenda the next time they meet, which will be the first Monday, and you can start from that point. So, Mr. Turner.
I was just going to say that, Mayor Burgess, assuming that the commission approves, I would prefer that it go back through the steering committee process and send that back to steering and let steering start over again and get a look at it, and then bring back a recommendation to the commission.
So is that your motion?
Yes, sir, I'd like to make that motion.
We have a second, Commissioner Dodd and Commissioner Gooch and others. All right, that being the case, any further discussion on that? That being said, all of you in favor of that, please say aye. Aye. Any opposed? All right, so that's how that will proceed from that point forward. Now, as a matter of courtesy here, Mr. Schaefer, we've got 7 more minutes before we have to have this hearing, and I sort of hate to start this discussion with respect to the judge selection. Mr. Schaefer.
I'd just like to mention that it's time to get a really good ham breakfast this Saturday morning. It's from 6 to 10 o'clock. The Laverne Rescue Squad on Gamble Lane, which is right off the old Nashville Highway behind the Civic Auditorium in Laverne. You all are welcome. It's cheap at twice the price, so we're only going to charge you all $10.
Commissioner P.
I have to agree with him. That's probably going to be the best ham breakfast on that Saturday. The next Saturday, however, there's one out at Kittrell would like to invite y'all to also. It's from 6 to 10. That'll be the 20th. Thank you.
Are there any other announcements or any other business? Commissioner Turner?
One thing for all elected officials, just a reminder that we need to turn in our ethics form and our financial information this month by the end of the month. Of course, you can do it online as well, but make sure you don't miss that deadline by the end of the month. Thank you, Mr. Chairman.
That's a good heads up. Thank you. Thank you. Okay. Commissioner Gurley.
Yeah, I was just going to remind everyone that the last time I looked, Rutherford County schools are closed tomorrow.
Yeah, we've heard that.
In case there's someone watching that didn't know that.
And the group of us, and those of you that are out there listening, the county will be open for business at 8 o'clock, and Ms. Nolan and Ms. Stevenson and I will start our discovery to decide if there's any reason they need to leave before the end of the workday. Okay. Now, before we start, I think we're going to take sort of a 5-minute break here. You guys can get up and move around, or you can sit there in your seat, but we'll wait to have this public hearing at 6:30, I think would be the right thing to do right now. Okay, thank you, ladies and gentlemen. It's now time for us to have a public hearing. We only have one request today, one rezoning request, 17-A031, on behalf of Mr. Matthew Bratton, located at 1619 Flat Rock Road. The existing zoning is residential medium density and commercial services on approximately 0.41 acres. Proposed zoning is commercial services on a site of about 7.3 acres. Mr. DeMosi, please give us more information.
Yes, Mayor Burgess, thank you, and good evening, Mayor and Commissioners. This property probably looks kind of familiar to you. The applicant recently rezoned a portion of this property, about 0.4 acres, to commercial services, the same zone he's asking for tonight, in order to enlarge an existing building business on adjacent property at 1601 Flat Rock Road. That was back in August of 2017. The Planning Commission's also reviewed and approved a site plan for that project back in October of 2017. Since that time, the applicant has indicated to staff a desire to either sell the remaining property or to perhaps expand the business further onto the proposed property that he wants to rezone tonight. So he's requesting the remainder of this property to be zoned commercial services, consistent with the 0.4 acres that he had rezoned last year. There is an existing single-family structure on the property. The property that would be rezoned commercial services does not allow for residential uses in the commercial services zone. However, this would be considered a non-conforming use as long as the use did continue and didn't expire any longer than a 30-month time frame. It could also be sold to somebody else who wanted to use it for a residence as well, and that would be consistent with our regulations. As far as any access, parking, landscaping, and whatnot, anything that was developed on this property would have to be done according to current county standards. The applicant was present, answered questions from the Planning Commission regarding his plans for the property. He stated that in order to pay for the improvements for the business on the site plan that he had approved back in October, he thought he might have to sell some of the subject property, which was really the main impetus for bringing this in. He also stated he had other property for sale, and if those sold first, he would just continue to live at the subject property, which he currently does. Some of the Planning Commissioners did have concerns about the speculative nature of the request, but ultimately the Planning Commission did recommend approval by a vote of 7-4 and 2 against. With that, I'll be happy to answer any questions you might have.
Any questions for Mr. Demosi? All right then, so please stand by just a moment, and we will declare the public hearing open on this request 17A031 for anyone that wishes to speak for or against this proposed request. Now is your opportunity to come forward and make your comments. Is there anyone that wishes to speak for or against this project? No one is standing to come forward. Hence, I declare the public hearing closed. Is there any motion? Commissioner P.
I'll make a motion to approve with all the recommendations from planning.
And the second, was that Commissioner Jernigan and Commissioner Phillips there? Further discussion? There being none, then, all of you in favor of that, please say aye. Aye. Any opposed? All right, thank you very much. Thank you, Mr. Demosi. All right. We have a process that was approved by you at the last commission meeting, so I'm going to carefully try to be sure we step through this carefully and thoughtfully and don't rush ourselves. But we're now in the process of starting the selection of General Sessions Judge Part 2 from the qualified applicants that you see listed below on your agenda: Mr. Ben Bennett, Mr. Derek Howard, Mr. Chris Oliver, Mr. Gary Patton, and Mr. Matthew Wright. Now, before we start this discussion, does anyone have anything they want to say? Mr. Stevens, did you want to say something?
Thank you, Mr. Chairman. As a local member of the bar here, as an attorney, I have professional relationships with several of these applicants, and also might end up practicing before the ultimate winner. And I believe it would be best if I abstain from the process and also from the votes, and I would request that the record reflect that.
All right, thank you. Any other comments before I take you through the minutiae details of how we're going to proceed? Mr. McAdoo.
Also, I may have a conflict of interest due to my businesses with my family, so therefore I am abstaining from being involved in this tonight, and this is based on confirmation from the county attorney.
All right, so let the record reflect that as well. Mr. Clerk, any other comments or questions before we start on this journey? Okay, all of you have attached to your agenda, excuse me, Mr. Jordan.
I have a question. What is a majority at this point? Does it take 11 votes still, or we're down to 19? I'm just for clarification.
Well, that's a good question there. We're so glad we have Mr. Hudson here with us. I have the Robert's Rules of Order here if we need to. if you need to look at that. Would it be okay, Mr. Jordan, if we let him look at that while we start some of this other process?
I just want it clarified before we get to voting.
Before we take any vote, we will do that. I have my book, as always. I haven't had to use it lately, but thank you, Mr. Hudson. All right. Each of you have before you, and some of this I'll remind the candidates so they'll know exactly where we're going with this, but all of you have a copy of what we prepared previously. But all 5 of these candidates which are qualified will be sequestered. That means they're going to go back in the finance conference room, and they will be brought in here one at a time. And you candidates, while you're back there, you're not to use your phone or other electronic devices to view or listen to what the other candidates' pre-deliberation statements might be. Each candidate, when you're brought back in alphabetical order, will be given up to 5 minutes to address the following discussion points and any other remarks they choose to make in the allotted time. Now, those discussion points, there are 4 of them. Each of you have already received, sitting at your position there, the written answers that each of these candidates have provided. So you have their answers to those 4 questions before you, and you can review those and evaluate those as you're talking and listening to each of them. After each qualified candidate has completed their initial presentation, the commissioners will be given an opportunity to ask the candidate questions to clarify or gain additional information. And we'll remind each of you, this is not a time that you're to be deliberating or promoting or supporting or disagreeing with what they've said. You're simply gathering information. There can be no deliberations at that point. Okay, qualified candidates, after that will be again sequestered in the finance workroom, and they will be brought in one at a time for any follow-up questions. This is still pre-deliberation. Again, the candidates are not to use their cell phones or other electronic devices. So there may or may not be additional questions. If not, we'll move on down through this a little bit faster. And after each qualified candidate has answered any follow-up questions, they will remain sequestered until initial nominations are complete. After that point, then we will have while you're still sequestered, the commissioners will have an opportunity to nominate who they choose to nominate for this judgeship. All right, so each commissioner after that will, by some roll call vote, and I may use this in some non-standard processes, will be given the opportunity to nominate each qualified candidate. We'll let you do that before we talk about the actual voting. You don't have to make a second. We just have to have a motion, a nomination. Again, there's no deliberation at that moment. After each commissioner has made their nomination, all qualified candidates who were not nominated are invited to come back into the courtroom for the remainder of the meeting. And prior to bringing in the nominated candidates, the commissioners will be asked if there's any additional questions of those people that have been nominated, and they can be brought back in one more time for additional questions. If there are no additional questions, the nominated candidates will be invited to come back into the courtroom here for a deliberation process. And the deliberation process will go as follows. Commissioners will cast their vote by voice roll call for one of the nominated candidates. And that's when I may use some discretion as to what order we do this, so everybody doesn't get first bite at the apple or as far as doing this. So we may make this a little bit random. A simple majority, which we will have to determine before we get to this point, what the number is, must be received by a candidate to be selected for appointment. And assuming this goes for multiple rounds, 5 minutes will be allowed for deliberation between votes. After each vote, the candidates with the lowest number of votes will be removed, if we haven't gotten a majority, from the list for the next round until we have a candidate selected. Okay, so I've gone through that pretty quickly, but you've had that before. This is your second go-round on doing this, since we had to do this previously. And almost exactly we're doing it the same way this time. Okay, so if there are no other questions, we're ready for Ms. Stevenson, and she is there to take the 5 candidates back there to the Finance Conference Room. Okay, did I miss anything? Mr. Gooch?
I know this situation has come up in the past prior, and I do believe that our rules indicate that there must be 11 votes to pass a motion, regardless of the number of members present or voting.
Okay, so
That's my recollection of our rules.
What are you telling us now? Repeat that so Mr. Hudson will understand it.
From my understanding of our rules, and this has come up in the past, that regardless of the number of commissioners present or voting, that a motion can only be passed with at least 11 votes.
Okay, he still has a bit of time to chew on that.
Yes, I mean, please look, my recollection in the past, that's what our rules
That's
say.
what you recall previously. Okay.
So that's the precedent you understand has happened in the past.
Yeah, based on our rules, it may be the same.
Yeah.
Well, we do have a commissioner's handbook that may or may not be in there. I don't know. All right. So we have everyone sequestered. We're ready for the first candidate to come out, and he has 5 minutes to come and make his comments to you, and then you can ask questions. Bring him in, Ms. Stevenson. Mr. Bennett. We had 21 people here to start with. Mr. Bennett, you may make your presentation, please.
Mr. Mayor, thank you. Commissioners, to each of you, good evening. My name is Ben Bennett, and I'm pleased to join you this evening in support of my appointment for our next General Sessions Judge. I believe serving in our judiciary is much more than a position and much more than a job. A judge is a commitment with high expectations and responsibilities. Having spent most of my life here, Rutherford County has prepared me to meet these expectations and accept the responsibilities that we all have of our judges. Our judges represent the example of justice in our community and are relied upon on a daily basis to be part of the solution to address and handle the legal situations that affect many of us. Judges are real people with real-world experiences, diverse backgrounds, whose core purpose is to administer justice by enforcing the laws enacted by our great state. It does not require us to check our kindness, our compassion, or our courtesy at the courthouse door. It does require a demonstrated ability to be fair, impartial, and accessible to those seeking their day in court. It does require a judicial disposition and temperament that is gained only from years of experience addressing the very matters that this judge will decide. Our county has made an extraordinary commitment to programs offering alternative sentencing. And I, too, believe in the second chances that these programs support. I can tell you firsthand, it does work. And many, given the chance, want to right the wrongs and make good in their community. The power of redemption is a feeling and often a very compelling factor for those given an opportunity to do better than they did before. These are traits that I have developed
over a 30-year legal career, starting as a deputy sheriff and continuing today in private practice, having represented hundreds of clients in the criminal courts, and as a special appointed judge, I have presided over thousands of cases on the court's dockets that this very judge will be asked to preside over in the very near future. This, as well as the global experience, is what uniquely qualifies me to serve as our next General Sessions judge and to contribute immediately to our judiciary. I have had what is sometimes the challenge and many, many more times the privilege of seeing this from the perspective of a police officer, seeing it from the perspective of a victim, seeing it from the perspective of a defense attorney, and seeing it from the perspective of a judge. So tonight, I ask each of you, in your deliberations, to consider my demonstrated commitment and experience in casting your vote to allow me to continue to serve our community as the next General Sessions judge. And with that, Mr. Mayor, I will yield the floor.
All right, now is an opportunity for the commissioners, if they have questions or concerns they'd like to have a little bit of dialogue. Commissioner Dodd.
Yes, sir. Mr. Bennett, you mentioned, made a comment about alternatives or second chances.
Yes, sir.
Can you elaborate on some alternatives that could be employed?
Absolutely. It's a very broad range, Commissioner Dodd. It goes everywhere from most misdemeanors, and there are exceptions, to some of our lower class felonies, and felonies in our judicial system are graded from A through E, some of the lower class felonies. Each of these charged offenses offer various programs, diversions, and other things that are offered through our probation services here in Rutherford County that give offenders that want a second chance a true second chance. It even extends in some cases to those that come before the court for speeding offenses. There are programs available that allow speeders who have not had tickets within a certain recent time period to do certain things from a class perspective, to gain more knowledge of perhaps how to drive a little bit slower, and there is a reward for that. The one thing that is at the common core of this, Commissioners, is that it is a joint venture of sorts between the courts, our Department of Probation, and the most important factor is the individual. They have to make a commitment to take advantage of this opportunity. Otherwise, it's not going to work, and it's going to force the court to act in addition to what it's already done. It ranges, Commissioner, the short answer, it ranges from everything from expungements of your record to ultimate dismissals of the charges, and depending on the charges and the disposition, it can run the entire range in any of those classes of criminal charges.
Then the follow-up would be, do you have an opinion on a very specific pre-trial diversion program or system? Would you advocate for that being codified or a protocol being created and that being implemented and the General Sessions judges collaborating on that?
Well, actually,
pre-trial diversion specifically.
And it actually is currently codified, Commissioner, 4035-313, as a matter of fact. And I don't know if it's good or bad that I know that. But it is codified. And it is something that is afforded offenders that are in that criteria range. And if they so qualify, and it is approved by the judge in our prosecuting attorney's office, then these people are given true second chances. There is a diversion period that ranges anywhere from 90 days to 6 months, and in some cases it can be years if the charged offense is a felony. But if they do everything that they're supposed to do during that time period, there is an ultimate disposition that can include the dismissal of the charges and the expungement of their record if they choose to take advantage of that.
Other questions? Commissioner Turner.
Thank you, Mayor Burgess, and Mr. Bennett, thank you for your services to our community as law enforcement.
Sir.
Very much appreciate that. One quick question, though, as we hear, and as you know, practicing law, the eyes of justice need to be blind. And can you share with us as a commission body a time where you had to take a legal position that conflicted with your personal beliefs? And if so, how did you handle that situation?
I can somewhat, Commissioner. It didn't necessarily conflict, but I can share with you one of the more challenging times that I had in which I was asked to defend a young man who was charged with attempted first-degree murder. And part of this case, and it ended up being a bench trial, but this case included me as the defense attorney defending a young man charged with what was candidly a violent offense. But through my processes of representing this young man and interviewing doctors and interviewing a lot of people in his family and in his history, I discovered that he had a true lifelong history that involved mental illness. And for someone like me, who has investigated and prosecuted individuals for first-degree murder, I'm not necessarily one that has always been one to subscribe to the not guilty by reason of insanity defense. And this opened my eyes and allowed me to see a really true example of how that application is applied. So again, it wasn't necessarily a conflict, but that was a tough hat to switch over.
Commissioner Baum.
Could you tell us what kind of temperament you think the next judge in this position should have, and then tell us a little bit about your temperament and how that would fit into the position?
Absolutely. As I said in my opening remarks, Commissioner Baum, this position is going to be supplemented by someone who has been involved in these processes and has seen these processes. And I'm fortunate enough to have done that. The temperament of a judge has to be first and foremost one of patience and one of understanding. There's a lot of times that people will appear in front of you that may not be represented by counsel, that don't necessarily understand the charges or even the legal process that they're engaging in at that time. It's important to be very patient with those individuals and understand the position that they're in. At the same time, you also have a responsibility to all those others that are appearing that day, as well as the efficiency of the courtroom to move that forward as well. But one of the paramount things that I would say, Commissioner, that you would need to exercise is patience, because a lot of times people simply don't understand the course of conduct that comes as part of being engaged in the criminal justice system.
Commissioner P.
Well, since you mentioned patience, would you describe a workplace situation that tested your limits of your patience, and how did you respond? And then in hindsight, would you have done anything differently?
And Commissioner, I'm sorry, I didn't hear the first part. A work situation?
Right, a workplace situation that tested your patience.
That's easy. And this goes back to my law enforcement career. It's quite frankly, it's not anything that I have experienced as a practicing attorney or as a sitting special appointed judge. But I can tell you, one of the most difficult times I had very early in my career as a young patrol officer, I had a gentleman that was fleeing, and he was arrested for driving under the influence. And there was a confrontation, and I was transporting him after the arrest, just to be very candid about it, this was in the late 80s. So we had the wire screens. We didn't have those wonderful plexiglass screens that we put in most of our police vehicles now. There were wire screens that had squares that were about that big. And he used that opportunity from Baker Road and Old Nashville Highway in Smyrna all the way to the Murfreesboro Hospital to spit on me the entire way. And my sergeant was right behind me. And bless their hearts, that one there tested my patience. But as a young patrol officer, what I was trained and what I knew to do as a person, and this is why I say Rutherford County has prepared me, because I was educated here. I went to Christiana Elementary School, Middle School, Riverdale High School, MTSU. This community taught me how to deal with that. My experiences growing up and being educated here taught me that I know what's going on here and I know what I have to do. And so that was one that tested it, but we got him on and it ended well. Didn't touch the brakes. Didn't touch the brakes.
Commissioner Allen. Let me read that, please.
Can you tell us about a time when your personal listening skills proved crucial to an outcome?
my personal
listening skills in a legal setting where your listening skills you feel like was crucial to an outcome?
There was. It's not a criminal matter, Commissioner. Quite frankly, it was one of my business clients that was involved in a significant transaction and change of businesses. And there was a lot about that business location and what was going to become of the new business location as well as the old business location. And it was complicated by factors that were well beyond the control of either party. And so we were sitting in a room at one of the businesses along with my clients and all the attorneys, and it required me to listen very, very closely as to the ramifications, because the financial ramifications for this particular event were significant. They were in the tens of millions of dollars. And the impact on the ongoing business was such that it could impact their service level as well. And this particular business represents a very high level of service in our community from a medical standpoint. So that was a very pivotal event and case in which my mouth was closed the entire time and my ears were probably turned sideways.
Other questions or comments here? One follow-up, Mrs. Allen.
Because you've been in this community so long and you've got such a history here, do you think there'll be times when you'll be conflicted out of cases, and if so, how would you handle that?
Absolutely. It's bound to happen. And yes, ma'am, I would be. I'm certain I would be. And the way you handle that as a judge is you simply take it upon yourself. It's what's called sua sponte, but it's a fancy legal term for deciding for yourself that you shouldn't hear this case, and you enter an order of recusal, and you sign that order, and then you send it to one of the other judges for them to hear that matter. And candidly, I think that's likely to happen probably more often than not if I'm selected for this position more frequently in the next 2 to 3 months. And then after that, I think it'll taper off, and it probably won't be as necessary in the coming years of service.
All right, any other questions? All right then, Mr. Bennett, thank you. You may be excused and return to your headquarters. And Ms. Stevenson will bring out the next candidate, Mr. Howard. But two of them have chosen to say they're not voting. So does that reduce the present and voting to 19? If you read that over there. But where is the rule? I don't, Lisa? You remember once you went down to my office and got the commissioner's handbook? It's, if you look at my desk and look at all those statutes and green books, it's up at the top left in a white book. You get Mr. Reggie to let you in there. Welcome, Mr. Howard, and if you understand the rules, you have 5 minutes to make your presentation, and they'll have an opportunity to ask you some additional questions if they so choose. So please proceed. And
good evening. I apologize for it taking me so long to get out here, but I'm getting a little bit quicker with it. Each of you I've provided probably what looks like a book on some of my thoughts on general sessions, but to make things a little bit easier, I've culled that down to some talking points that I'm going to try and address. My name's Derek Howard. I'm an attorney here in Murfreesboro. Moved to Rutherford County in 2003. I've been practicing criminal law here in Rutherford County since 2004. And since that time, my primary practice has been in our general sessions courts, of course, in front of Judge Lowry, Judge McFarland, Judge Tidwell, now Judge Ishod. In the last 13 years, I've probably handled almost every type of criminal case that an individual could be charged with. I'm sure there's some out there that I haven't done, but everything from a public intoxication to murder cases. in doing so, that's brought me into contact with all the people who make our judicial system work. Our judges, our court officers, our clerks, our law enforcement officials, everyone who on a day-to-day basis makes our court system work. I know if you look through your notes that I've presented you with, we see several hundred cases almost on a daily basis just in our general sessions courts alone. In the past, I have sat as a special judge for our judges if they were out of town or unavailable. I've handled their dockets in the past. I understand the processes that goes through on a daily basis with those dockets and what needs to be done, and that's given me the ability to come up with some ideas that I think might help us expedite some of the processes in our general sessions courts. When we're looking at what the court's general responsibilities are, it is a court of first impression. That means most criminal cases are brought to general sessions first. Likewise, it also has the most players, the most actors. You have your victims, your defendants, your police officers, victim advocates, defense attorneys, district attorneys, all working to resolve a docket that may have several hundred cases that day. There's two types of cases that can be brought in general sessions. Those are misdemeanors, or in any court actually, but misdemeanors and felonies can be brought in general sessions. What you generally see is the felonies will either have what's called a preliminary hearing or be bound over by the defense attorney to the grand jury to decide if it needs to go on to our circuit court. Any type of misdemeanor case can be disposed of actually by a trial, bench trial in general sessions if the defense attorney and the prosecutor agree to that. Those misdemeanors would be anything from a public intoxication to possibly a domestic assault or driving under the influence of alcohol or drugs. We have in our courts our daily dockets, which would deal with any type of case that could be brought, but we also categorize those here in Rutherford County into specific days. For instance, Judge McFarland hears violations of probations on Friday, and Judge Judge Eichod now would hear her violations of probations on Mondays. The reason being, once a person violates probation, they have to go back in front of the judge who sentenced them or accepted their guilty pleas. We also have, our judges are responsible for our Veterans Court, which is one of our newest endeavors here. Gives us the opportunity to take veterans that have been charged with a criminal act or have come into our system, address those specific needs, look at if there are issues, can we help them get an education, can we help them further their education, are there any substance abuse issues, are there any alcohol issues, work with those people to put them in a better position to come out of that court with not such, possibly with no criminal charge on their record, but say it were a felony, perhaps it's reduced to a misdemeanor. We're really, and that's one of my favorite courts that we're doing now. We also have a domestic violence court, which Judge McFarland handles on Thursdays. That is any type of domestic violence case brought in Rutherford County. That is a very heavy docket. Judge McFarland generally handles, apologize, I can get this.
Mr. Cush will assist.
Judge McFarland generally handles that docket on his own, but it does bring into your victims, your witnesses, your defendants. You have domestic violence coordinators who talk to these victims, see what needs they may have, try to work with them to help resolve these cases. And likewise, you would have your defense attorneys and your prosecutors. We're doing a mental health court, similar to the situation with our Veterans Court here in Rutherford County. It allows us, some of the issues that we see or that I've seen as a defense attorney in the years are lots and lots of people with undiagnosed mental health issues and drug and substance abuse issues, and obviously an opioid crisis in Middle Tennessee and Tennessee itself, I would say contribute 60% to every criminal case that I've handled in the last 5 years. One of those factors comes into play. Mr. King, Trey King, runs our recovery court program, and that's a fantastic program as well. General Sessions here in Rutherford County takes in people who are convicted of DUIs or charged with second or subsequent DUIs can petition to be entered into that court. Excellent program. It helps people turn their lives around. Likewise with our drug courts, that's administered by Judge Bragg, but that's something that you can look at for people with these underlying addiction issues. One of the things that we look at now and that consumes a lot of our judges' times are the acceptance of guilty plea agreements. Typically, a defendant entering a guilty plea will have a judgment form on one side of a page, which their attorney will go over. It lays out the specific data to that person, the charged offense, the conviction offense, and the sentence and special conditions that that defendant would have under that plea agreement. On the back side of that is a list of the constitutional rights that each defendant has. What we're doing now, and what I would like to see us try to move towards, is what we're doing is reading that entire list to each defendant that comes into the courtroom over and over and over again. I've seen in other jurisdictions, some courts have used systems where they have a teleprompter. Each defendant is asked, do they know their rights? I think Williamson County uses a mechanism where they read all of the criminal defendants their rights at once, and it speeds up the process throughout the day. And now, as I turn my focus to some of my priorities, as a General Sessions judge, guilty pleas I've listed as one of my first priorities. I think that's an area where we could make up the most time and save and the most effort and money in our system and work towards a better judicial economy. And that's some issues that I would like to look into. Another issue that we see a lot is the driving on suspended license charges. People can lose their license for traffic violations, fender benders that forget to mail in something to the Department of Safety, but once they get into this cycle where they've lost their license, until recently, within the last year, our legislature's changed that. It's almost a self-perpetuating cycle where they lose their license, but they're going to work, they get stopped for driving without a license. So then when they plead guilty to that, they lose their license for yet another year. By the time they're eligible to get their driver's license back, they owe thousands of dollars in court costs and fines, plus another thousands of dollars to Department of Safety to get a new driver's license.
Mr. Howard,
Yes,
is a matter of trying to be even-handed and equitable. I think you probably exceeded the 5 minutes, and maybe you can weave some of the rest of this into some questions that may be asked, if that's all right with you. Now then,
absolutely.
A time for questions, please. Mr. Dodd.
I appreciate you touching on expediting the docket, but I'm interested in your thoughts on pretrial diversions, alternatives to bounding something over. To me, there's another clog later on in the system. So if you could speak to alternatives to binding over.
Sure. Pretrial diversion, for those of you who don't know, is a mechanism that would allow a defendant who has been charged with a crime but has no previous criminal history to essentially put that charge on a shelf. If they pay their fines and court costs, pass drug screens, attend anger management, whatever conditions there may be, if they successfully complete that program, then at the expiration of a year, they can go back in front of our General Sessions judge and ask that that charge be dismissed and expunged from their record. And we do a lot here where what we call a retirement, it's essentially the same thing. It does prevent a lot of cases from getting to the grand jury that probably should not. It's not as formal in that there is generally not an application sent to the Tennessee Bureau of Investigation. Another aspect or something that we could look at, what we do is known as a judicial diversion. There's also a pretrial diversion. It's frowned upon by district attorneys throughout the state because it requires them to do a little bit more work than they normally would. But there are a lot of people that we see who would qualify for that pretrial diversion as well. That also would prevent quite a few cases from going to our circuit courts or to our grand juries. and release, or give a little bit of relief there as far as their dockets go.
May I follow up? Philosophically, are you an advocate for that pretrial diversion, even though the DA might not appreciate it?
Absolutely. Yes, sir. Generally, what you see with people who would be a candidate for a pretrial diversion or judicial diversion is someone who's never been in any trouble before. They don't have a history of entanglements with the law or being called out. And essentially what it is, it's a mechanism to say, okay, we're looking at your past. For instance, you're doing good in high school, you're doing good in college, you're working, you've got these things going for you. We don't want to punish you right now. We want to see if you can stand on your own 2 feet. Here's your chance. We're going to put you on this diversion. You do what we ask you to, and the benefit to you is it's dismissed and expunged from your record. So yes, sir, I think that's an excellent program. I do. I'm an advocate for any type of diversion.
Other questions? Ms. Allen?
What approach do you feel like is best suited for a first-time DUI offender versus a multiple offender versus someone with substance abuse?
Can I get you to clarify that before you sit down, Ms. Allen? When you say approach, do you mean as far as treatment versus punishment versus, tell me what you're looking for.
No, that's exactly the line of thinking I want you to follow.
Obviously, DUIs are a huge problem here in Rutherford County. It's probably 50% of my criminal practice. I mean, it's a large number here, and the difficult thing is you can't categorize every DUI offense into one pinhole. A lot of times as a defense attorney, when I meet with someone, I can tell, look, this guy is out drinking all the time. He's got some underlying issues. And my approach is to try and steer those individuals towards some type of treatment with their plea agreement, some type of oversight with their probation, such as drug screens or alcohol screens. With what we've got now, when you see these multiple offenders, our recovery court, I think, is our absolute best approach for a multiple offender here in Rutherford County. It's a huge commitment on the behalf of the defendant, but I can tell you from experience that every client that I've ever had who has completed that course, it's changed their life for better. And so I'm a huge advocate for our recovery court programs as well. Sometimes, and you have to look at it, sometimes you may have an individual who had a glass of wine with dinner. They get stopped. The officer, for whatever reason, thinks they may be intoxicated when actually they're not. Well, that's a different approach than someone who's had a 6-pack or a 12-pack of beer and their blood alcohol content's 0.25, barely standing up. So it's kind of a case-by-case basis. We have a specific district attorney who deals with driving under the influence charges. In fact, we probably need 2 or 3 more of those. But she does a good job of talking to and listening to the attorneys and what their recommendations for particular clients are. I know I've kind of gone all over the place with your answer, but it's just hard to pigeonhole one specific category of a DUI offender. Obviously, I think our recovery court is the best approach, even for first-time DUI. Now, they don't have the time or the experience to do it, but there are programs available that help us address those needs in our community.
All right, thank you. Other discussion or questions? All right then, Mr. Howard, thank you very much. Mr. Cush may assist him here.
Thank you, sir. Yes, sir. 16, carry all kinds of stuff.
Welcome, Mr. Oliver.
Thank you.
May present your findings and your comments that you'd like to make.
All right. Well, ladies and gentlemen, good evening. I'm Chris Oliver. I believe that our justice system is one of the things that makes our country so great. Without the fairness that it provides, we'd all be subject to oppression, to chaos in our community. I believe a judge has a duty to provide a courtroom and a forum that encourages fairness and provides fairness. I believe efficiency is important, but care must be given to ensure that we don't sacrifice fairness and the laws of this state. A criminal general sessions judge must preside over cases ranging from minor traffic violations to preliminary hearings on serious felonies. The judge is responsible for sentencing those that are convicted of misdemeanors. And I think it's important for the judge to understand that the judge alone is ultimately responsible to ensure that that sentence is appropriate under the law, and that he's the one that alone must answer to our maker and the citizens of our county to ensure that that sentence is appropriate under the laws of our state. Simply put, a judge has to follow the law. Most people of our community will never enter a trial or a circuit courtroom, but many will encounter a general sessions courtroom, and the impression that they get from that court will have an impact on the way that they view our criminal justice system and our local government as a whole. Now, this judge will likely be taking over the responsibilities of the jail docket. We've been down a general sessions judge for a little over a month. And with that in mind, a top priority for me would be taking office immediately. Because of my background, I can begin efficiently running a docket as early as tomorrow. I would also be conscious of the overcrowding issues in our jail, the pretrial release process, and work to help create safe and responsible alternatives to continue to address those issues. I want to assist and expand on our recovery court programs to help reduce the likelihood that a person will reoffend and become a productive citizen. Again, I believe it's important that we select a judge that doesn't need several months to learn the process, that can start immediately, and I can do that. My experience working with this court directly, assisting the judges that served in this position for over 2 years, gives me intimate knowledge on how to run this court from beginning to end. For the past 5 years, I've practiced in this court on a daily or at least weekly basis. I was in this court for 3 days this week. I believe this position requires patience and humility. I believe I possess those qualities, but I also commit that I'll continue to work to improve and maintain those if I'm fortunate enough to be selected. I'm not one to back down from making tough decisions that I believe are right. I believe that any type of corruption in our government cannot be tolerated. I am younger than the other judges that are currently serving in our district and our county, and I can see how it may be tempting to view that as a weakness for me. But I urge you to consider my unique experiences that none of the other candidates can possess. And I'm the type of person that'll be conscious of that and that'll work harder and be more prepared. There have been many times when I've been the youngest lawyer in the room, but I can think of very few times when I wasn't among one of the most prepared, and that served me well. Now, I did not apply for the circuit court appointment that created this vacancy, and I don't have any desire to be a circuit court judge or just any judge. I want to be a criminal general sessions judge. Most importantly, I sincerely enjoy helping others and identifying problems that just naturally interest me. I believe that very few people step into a courtroom without the need of help or without a problem, whether it be a defendant, a witness, an officer, an attorney for either side. While as a judge, I won't be advocating for anyone, but I do believe that I can provide impactful help to all of them. I'll provide an open courtroom that's fair, safe, and efficient, patience, humility, and respect, attention to alternatives such as our recovery court programs, and I can listen and make thoughtful decisions that are grounded in the law. I'd be honored to serve our county in this important role in our justice system. I thank you so much for your consideration throughout this process, and I'll be happy to address any questions you might have.
I think now's the time for questions. Mr. Bob.
I believe you served as a substitute judge in this court. Could you tell us a little bit about your experiences in that capacity?
Yes, sir. I have served as a substitute judge, primarily at the jail docket, where I've had the opportunity to serve as a substitute. And to be honest, the position, I think it's from my experience as a law clerk and court officer and practicing that court every day, it just seemed to come very naturally to me. I hope that helps.
Commissioner Turner.
Thank you, Mayor Burgess. Evening, Mr. Oliver. Just real quick, you had mentioned some of your personal convictions about corruption and things like that. Can you describe to me and to the body ethical dilemmas that you might have encountered across your career in law, and how would you handle those from the bench, given what we know and what we expect publicly from judges when they hold trials?
Sure. Well, as we all know, the law isn't always clear as a bell. The laws oftentimes give us discretion, but oftentimes it doesn't. You know, a judge is going to be faced with decisions that are going to be difficult, but no matter what, if the law is clear, he has to follow the law. As an attorney, you know, there are a number of ethical issues that we are tasked with following, and that's a priority for me, both in dealing with my clients and dealing with the court and dealing with the other side. Hopefully that helps answers the question.
Just a quick follow-up. Do you have any specific examples, though, where you faced some sort of ethical or moral dilemma, and how did you handle that in your practice?
I may be coming up short with any personally for me right now. There have been times when a question has came up and I've had to reference the rules of professional conduct, but I cannot think of something specifically right now that I could share publicly for sure.
And that helps too. I mean, sometimes it doesn't come up like that, but those types of instances are examples I was looking for. So
yes, sir.
Mr. Johnson.
Yes. I was looking through the book. I was impressed with your other credentials. You seem to have come from a pretty humble background. Could you just go into a little bit of detail about your background, about your work ethics?
Sure. I was blessed with a great family to grow up with. I guess for most of my young childhood, I thought everybody's parents came home from their full-time job and then went to the fields with their family to help. We were by no means poor at all. I mean, we were always taken care of, but my family was always had a strong work ethic and made it clear to me why that was important. So throughout my high school career, I always had some sort of job, whether it be working on the family farm or working outside of the family farm. On into gaining my undergraduate degree, I had a small business of my own. I had a dump truck that I hauled gravel, sold it to farmers and loggers and other people in their community. I was fortunate that I was able to basically support myself through school doing that. I also had other jobs, working as a construction laborer, then assistant superintendent while I was in school. Graduated in the recession, which was difficult. I began law school at that time, but through the help of good people, I was able to finally find a position that was better suited as I was going to school at night than roofing during the day and wearing myself out. And then thankfully I got the job working here. That was a tremendous opportunity, and I've just had a really good experience all along the way, and I'm thankful for everybody that's helped me.
Further questions? Mr. Dodd?
Yes, thank you. Your comments about safe alternatives to trial intrigued me, so I've been kind of following that line of questioning, but I've had to educate myself, so bear with me. I've discovered that pretrial diversion is codified. It's available to judges. But here's where you can educate me. Is Rutherford County working on a specific program? The General Sessions Court, is Judge Ishod working on a more detailed process? And would you be an advocate for that process, for pretrial diversion specifically?
Yes, sir. My understanding is there is at least discussions being made about looking at pretrial diversion process. Pretrial diversion is only available for someone that does not have a criminal record, that is not charged with, comparatively speaking, a serious crime. And it provides an opportunity to them, for that person to, one, show the court that they're remorseful and that they wish to take a better path and to complete certain conditions and to stay out of trouble for a certain amount of time, and it can help them avoid jail and also a conviction. And I am an advocate for that type of thing. I believe strongly that when crimes are committed and a person is convicted, that there must be consequences. But I think we have to look at those alternatives to make sure that we're helping reduce the likelihood that somebody's going to reoffend and not just creating a revolving door.
Mr. P.
I had the privilege once upon a time of serving on a jury. And one of the particular case that I sat on, I have a couple of questions, and maybe you can tell me your thoughts on them. In particular, it was a DUI case, and we as jurors saw a real grainy film of a guy in a parking lot who seemed intoxicated, in my opinion. And after we discussed it, all of us except one agreed that, yeah, he was drunk, even though he claimed his wife was driving. But we looked at the film again. We came to the conclusion, yep, this guy was DUI. So after the case, we found him guilty. After the case, the judge instructed us, and this is the thing that bothered me, was that this guy had been charged with DUI. That was his 8th DUI charge. And that was the first trial, and he'd made some kind of pretrial diversion or whatever it called. That he made an agreement basically if he was found guilty on this, he would plea, I assume, guilty on the rest of those charges. It bothers me, first of all, that it took 8 times that he was arrested, unless he did that in rapid succession, say within a day and a half, that there were 8 counts before he was brought to trial. And the other thing that bothered me was this. Okay, you got the option of having a judge see you on his own or a jury trial. Is that, I am correct on that, right? Okay.
Defendant can select, yes, sir. The state can have some say in that as well.
Well, here's the thing that bothered me is the judge told me that he was aware of these other counts, but the jury was not allowed to know about these other counts. Now, he would have been the same person that would have been judging this particular case. So I want your opinion, first of all, why so many counts before he went to trial? And then secondly, what's your opinion on that? I mean, should not the jury have the same information that the judge has gotten?
Sure. So as to why so many counts, is that something that should happen? I would submit it's probably not. Without having more information as to how that he got to that many counts, that many counts could have been spread over a period of 20 years, possibly more, depending on when that those offenses did occur. So it's certainly a serious issue when there's 8 offenses on a DUI and the person, or 7 offenses and the person's now being on trial again and convicted. as to the jury not being allowed to hear about those prior convictions, I've been involved with trials just with that very issue. And our law is very clear that the judge has to keep that from the jury, because there's a danger, according to the law, there's a danger that the jury will impute guilt on him because of his past actions and may not focus on that action that's at hand when they're asking you to prove him guilty or innocence there.
Now, the priors were arrests, not trials. But you advocate that the judge is actually got more sense about him as far as looking at a victim or a DUI person versus a jury.
That's a great question, and I want to be clear that I'm not advocating that position and saying that you could not, or a jury could not differentiate or separate those past actions. But the current state of our law now tells the judge that he has no choice but to do that. If the current law now tells the judge that if that information gets out to the jury before there's a finding of, or before the trial or during the trial, he may very well have to call a mistrial.
Other questions? Mr. Schaefer.
Mr. Oliver, you mentioned the word patience several times. And to me, the definition I've heard of patience is long-suffering or perseverance. I want to go back and follow up a little bit further on what Commissioner Dodd, and this comes from the questions that are in this book that we got first.
Yes, sir.
And in it, I'm going to read here, it says, an immediate challenge is the population to our jail, specifically those not yet convicted or sentenced, and the need to implement safe alternatives to the current pretrial release system. I fear that the system implemented in the past does not afford the rights under the Eighth Amendment, which I assume is a speedy trial.
That's excessive bail.
What?
Excessive bail.
Excessive bail?
Yes, sir.
Well, that's what I was wondering, how does patience fit in with that?
Sure. So I hope I understand the question correctly. Our justice system requires and demands a lot of patience from all parties, whether you're the judge, the defendant, the attorney, the public. It's difficult to get the wheels to move very, very fast. I'm trying to determine if you are speaking of whether or not somebody being held pre-trial may need more patience.
To me, what you said in here is repercussions against the county. Okay, but if the Eighth Amendment's second bail, I thought that was a speedy trial or something like that, and they weren't getting it, and that's why I was wondering how would patience fit into that, from the simple reason that the system, I guess you're saying the system we have doesn't work right now. And do you have ideas of how that?
Yes, sir. So the reason I put that statement in there is because I think it's important that we review our current system that we have as far as how we evaluate and decide what we were going to do with those individuals pre-trial to avoid potential suits against the county due to that nature. I'm not saying that what we're doing is definitely wrong and will definitely lead us to lose that lawsuit, but I personally would want to take a really good review of that to ensure that that's not happening and that those rights are being protected as well. That's the other side of that.
Right, Mrs. Allen.
I had another question, but this is sort of my follow-up to Commissioner Schaefer's. In the handout that you gave us, after you talked about being conscious of the overcrowding, the next statement you made was that you want to expand and assist our recovery courts. Can you give us an example of what it is you're talking about and what you're thinking there?
Right, and I think looking at those pretrial issues and possibly being able to expand some of those. If we can identify that someone is in need of certain services, then we may be able to make those options available, or at least recommend those, or at least whenever maybe, for instance, whenever a judicial commissioner may be reviewing that person and their eligibility for release and all the factors that they're supposed to go through, that may be a good time if they can to start identifying those issues. So that kind of goes into that pretrial portion of it. As far as expanding the current recovery court programs that we have now, 3, 4, 5 years ago, I don't know if I could have guessed that we would have the recovery courts that we do now. So I don't know that there's one available that I could just say, pick this one and we're going to put this one here, but I would want to encourage the use of the ones that we have and expand those. And it's not something that everyone needs. It's not appropriate for everyone. I certainly don't want to make that, I don't want to seem to come off saying that, but if we can use it, I definitely want to encourage that.
Any other questions? All right then, thank you very much, Mr. Oliver.
Thank you.
Yeah, you'll go back. All right, welcome, Mr. Patton, and you may make your remarks here to this group, and then they may have some follow-up questions.
Okay, well, we'll see how it is being next to last, but anyway. Good evening, Major Burris and commissioners, friends, and neighbors. I want to thank you for this opportunity to be considered for the General Sessions judge position tonight. The first question was summarize your understanding and philosophy. It is the duty of the General Sessions judge to represent our community by upholding the laws which bind our society with the idea of balancing and promoting fairness in our judicial system and protecting the rights of our citizens. Part 2, General Sessions primary deals with General Sessions Criminal Division handling traffic tickets and misdemeanor criminal offenses. General Sessions is also an initial step in the judicial process for violation of our laws. The court works for the district attorney's office to hear cases on small offenses that carry fines of $50 and no jail time, such as the traffic tickets and violations of county ordinances. In misdemeanor cases, which are of greater magnitude, which small cases the court holds an arraignment hearing, which is the initial step in the criminal process, wherein the defendant is formally charged with the offense and is informed of his constitutional rights. The court also advises the defendant of their right to a trial by jury and to be prosecuted only by presentment or indictment from the grand jury in that event. The court is required, if they plead not guilty, the court is required to hold a preliminary hearing within 10 days and either finds or doesn't find probable cause. And that probable cause means whether a crime was committed and whether that defendant likely committed it. Well, many cases are settled between the district attorney's office and the defendant. It is the judge and the court's job to hold a preliminary hearing on a not guilty plea. Read the rest of it. What are the 3 top priorities you think you should focus on, the General Sessions judge? Uphold the laws to protect our citizens, but also promote fairness and good judgment in our judicial system, utilizing all resources such as mental health and veterans and drug court programs and other pretrial release programs to deal fairly and quickly with the caseload. Introduce more electronic audiovisual equipment to the docket and when you can conduct initial appearances to relieve courtroom congestion. The system should utilize these resources in cases for granting continuances, appointments of counsel, etc. Also, we should allow attorneys and defendants to check in on first call online, such as using a touchscreen kiosk like we have in so many of like hospitals and doctors' offices now. The third thing I come up with was attempt to better our docket management to alleviate overcrowding. And with that, I think we can stagger the call times. Right now, you call at 8 o'clock, 5 days a week, but we could stagger those times 8, 9, and 10, maybe to eliminate the overcrowding. Because usually the halls are full down there at 8 o'clock, and you could stagger that and maybe eliminate some of that. My personal strengths. I am blessed with the education, experience, and maturity and the temperament to fulfill the position of General Sessions Judge. I've been licensed to practice law for over 42 years and have a legal background in areas of administrative law, business law, and private practice with emphasis in civil litigation. I have participated in criminal cases in both state and federal courts. I am no stranger to the first floor of the courthouse, which is where our criminal general sessions are located. I simply chose not to limit my practice to that specific area of my law. My diversity in the practice of law will assist me in implementing the recovery programs that we've been pushing in general session. That's mental health, veterans, and drug courts. I'm admitted to practice in Tennessee state courts, U.S. District Courts for Middle District, Tennessee, and U.S. Bankruptcy Court for Middle Tennessee. My experience in law, as well as business owner and farmer, and my tenure from 96 to 06 on the Rutherford County Board of Education have given me the appreciation and insight of being a good steward of our county's financial resources as we deal with our county's rapid growth. Why am I interested? I have called Rutherford County my home for over 50 years. I came to Rutherford County in 1960 with my parents. My father was an Air Force officer stationed at Stewart Air Force Base. After he retired in '81, my dad started his second career as a professor at MTSU, Aerospace Department, where he taught for over 30 years before his second retirement. I graduated from Smyrna High School, Middle Tennessee State University, and Memphis State Law School. I've been blessed to raise an amazing family here in Rutherford County. Rutherford County has been very good to me by allowing me to have a successful law practice, business opportunities, and farming. My neighbors and friends have honored me in the past by electing me to serve on the Rutherford County School Board. During my career, I've had the opportunity to mentor young attorneys. It is my desire to continue to serve our dynamic community of Rutherford County. For years, we have experienced growth, which our community leaders, such as y'all, and citizens have faced and managed. Our judicial system has also had growth demands placed on it, and I feel I am best qualified to assist in meeting those challenges. Thank you.
All right, now then we have an opportunity for our commissioners to ask some questions if they so choose. Questions for Mr. Patton. Mr. Turner.
Thank you, Mayor Burgess. Thank you, Mr. Patton. Just one quick question. Can you explain just for a little bit your philosophy as it relates to public involvement, being in the community as an active judge, and kind of what your view is on that relative to how would that translate to how you operated from the court?
Well, I think some good examples, like Judge Bragg, he's involved in a lot of community organizations. But we also reach out, like the drug court. You participate in veterans courts to assist people who have a lot of trouble. He's active in the local bar. He's also active at the state level as far as that goes. In private practice, like myself, when I was in corporate law, belonged to a plethora of organizations because we got paid to do it. It was great and things like that. But then when I went into private practice, it's the demands of your time. And one of the things that about the school board, when I went on the school board, was a lot of my free time was gone. And I devoted sometimes over 20 hours a week or maybe even more to school board activities. I was thinking tonight, we were talking in there, that implementing 21st century courtrooms technology would really help the flow of the numbers down. They were talking, numbers in there like 300 a day right now going through general sessions part 2. In order to expedite that and quit tying up so much of the courtroom times, I know we have a new courtroom coming up, a new courtroom building, but I think, like I said about the kiosks, I think we need to introduce more computers. And some of y'all were still here, but in '96, when I first got on the school board, the big argument was about computers in the school. And now we look back and say, are you kidding me? You know, but back then, a computer, even a small one, was like $1,000. And it was a lot of money for the county to come forward and pay for those things back then. But technology can help, and we need to maximize the use of that technology. And that's one of the things that I learned in my own law practice. Started out down here with Scott Daniel and Bill Burton. We got a law office that probably had 10,000 volumes of books in there they accumulated over the years. And now I carry a little laptop about the size, or a little iPad about this size right here. I just go online and look all this stuff up. It's amazing what you can do. And that same thing needs to be done in how we do our general sessions practice. They do it in other counties. Davidson County is really, if you go down there, you see they got the screens, and they do a lot of stuff different down there than here. But hopefully we can implement that with the help of the county commission, the help of those fundings, those dollars, we can get that done.
Questions? All right, I think they don't have any more, Mr. Patton, so thank you very much.
Okay, thank you for the opportunity.
Ready to opine. Whether they're here or not, it takes a little both. There's 21 of them here. All right, Mr. Wright, thank you and welcome. And now's your opportunity to make your opening remarks and maybe to be followed up with some questions. Thank you.
Thank you. First, let me say good evening. I know it's a late hour, and I hope you're not too tired. As you're aware, my name is Matthew Wright. A little bit of history on me, and my application resume goes into more detail, but just briefly, I got my Bachelor of Science in Electrical Engineering from Tennessee Tech back in 1991. I graduated from Nashville School of Law in 2001 and was licensed that same year. For the first 5 or 6 years up until December of 2007, I was a private practitioner. I did a variety of law. I started off in bankruptcy law. I did some divorce, some criminal defense. I didn't do a lot of divorce. I kind of lost a taste for that. Anyone who's practiced that area can understand why. In December of 2007, I took a job working for the Department of Children's Services as the attorney representing Rutherford County. So for the past 10-plus years, I've prosecuted civil cases on behalf of the department. When a child is abused or neglected and comes into state custody, I represent the department in proceeding against those individuals. And in a number of cases, you'll have companion criminal charges as well. So I get a lot of familiarity with that crossover. I would estimate, because the majority of my cases are contested, you don't have a lot of settlements, especially in termination of parental rights, because individuals are losing their children. So I would estimate over the past 17 years, I've tried over 800 cases. This includes preliminary hearings, similar to, it's the same burden of proof, probable cause that you would find in general sessions. I think it's important to note that I have nothing but the greatest respect for my colleagues. I know the majority of them, and they're well respected in the community. I think I would prefer to distinguish myself from them, not so much what is similar, but what is different. Number one, I think you have to look at the time of practice. I've been practicing for 17 years. Mr. Oliver's been practicing for 4 or 5, Mr. Bennett for 8, and Mr. Howard for 14. So I've been practicing 3 times as long as Mr. Oliver, twice as long as Mr. Howard. More than twice as long as Mr. Howard. And the only person that's been practicing longer than me is Mr. Patton. He's got me beat by a landslide because he's been practicing 42 years. He's been in this community for a long time. I think the other factor that distinguishes me from all of the applicants is what my experiences have been. In the juvenile court, in the cases I have, I deal with drug abuse, mental health issues on a regular daily basis. And I think that ties in to this General Sessions position, because one of the goals of this General Sessions position is to address the overcrowding that we have at the jail. And what you see a lot of right now is you'll have individuals with drug addictions, and they'll go out and commit misdemeanor crimes to get money to buy street prescription drugs, opioids, heroin off the street, and then they get incarcerated. And then when they get out, that drug abuse, that drug addiction has not been treated, so they just go out and commit another crime and then get reincarcerated. I think we have to try to address the root cause of their drug addiction so that, number one, that makes them better citizens. It lessens the burden on the taxpayers from the reincarceration of these individuals. There's other avenues of rehabilitation rather than incarceration. Incarceration is not always the only option, and I think that's important for this position. And I guess I'm very passionate about the drug abuse that goes on and the level of it. And I'll tell you, just as an example to illustrate where this is, and without violating any confidences or confidentiality, without naming any names, just as recently as last night, 11:54 p.m., I get a call. There's a child that's of elementary age that's in state custody. Her mother just overdosed, is on life support. She's not going to make it. That child is going to lose her mother because of drug abuse. Going to grow up her entire life without her mother. That shouldn't have to happen. And I think whenever we have individuals who have drug issues, who commit crimes, and go back in and we do not treat their addiction, all we're doing is making it so when they get out, they're going to go back out and they're going to rob somebody else. They're going to go steal whatever they have to steal so that they can go buy some more drugs. And we better our society and better our community if we address these issues through treatment other than incarceration. And also it lessens the burden on the taxpayers as well.
Now, Mr. Wright, in fairness and equity with the other folks, we've a little bit past our 5 minutes, so I'm sure there may be some questions, and you can expound a little bit further on some of those things you didn't get to say that you wish to say. Mr. Dodd, are you picking up your
Yes, sir.
mic there, sir?
I'm motivated, thank you. I've been intrigued by the conversation about diversion, alternatives, fighting recidivism or creating recidivism. And so, but I need you to educate me as a layman. I understand there's some diversions in the code, but can there be a process created in the Rutherford County General Sessions Court that allows you judges to collaborate on diversion alternatives, or like you've mentioned about the drug abuse and can we unclog our system? So, or is this just simply the judge's prerogative?
I think it behooves anybody in this position to reach out to the other general sessions judges, get their input. In the position I have now, when I make a decision, I consult with a multitude of caseworkers, mental health professionals. We'll have assessments done on what is the needs of this person. They'll call it a clinical intake, or it'll be an alcohol and drug assessment, and it'll come back with recommendations. And what you'll see a lot of is these individuals who have drug addictions, drug addicts get a bad name. I don't mean to say that they shouldn't be doing what they're doing, but you'll have some people who had an injury, they had to get on prescription pain medication to deal with that, and then when they got off of the injury and it was all resolved, they couldn't kick that addiction that they had developed when they actually needed it at the time. These individuals, you can help them through an assessment. A lot of it can be through counseling. They may, have other issues as well. Because what we also see a lot of is with these drug abuse, these drug addicts, you'll see a lot of mental health issues. We'll have a lot of individuals, and I've seen this on a daily basis in juvenile court, individuals who are self-medicating. Either they don't have insurance or they haven't figured out a means to treat their mental health issue. So they take heroin, they take cocaine, they take methamphetamines, and when they do that, it causes additional issues. It causes additional burdens on the taxpayer, additional damage to children, because a lot of what we see, and one of the things that bothers me more than anything else is we have a lot of mothers who, when they're pregnant, are using drugs like methamphetamine, cocaine. I had a case not long ago. Mother used it on a daily basis. You have to tie those in, but I've dealt with those individuals. I've seen those parents, and I was a parents attorney for 5 years before I was a DCS attorney. And when someone walks into a courtroom, you develop the skill, just looking at them, you can tell, this person's using some drugs, or this person has a drug issue, just from their affect. It's not something I can really describe to you how you can tell that. Just over the years of working with those individuals and seeing those individuals, I think if we can get treatment, you keep that person from being reincarcerated, keep them from committing criminal acts, they get a job, they pay taxes, we save money from having to pay for incarcerating them. That funding can be used to support school programs, support other programs that teach about prescription drug abuse, other drug abuse. I just think overall, treating the issue instead of just locking people up and then putting them back out on the streets, we better them and our community as a whole.
Other questions? Commissioner Turner.
Thank you, Mayor Burgess. Mr. Wright, you had mentioned earlier some of your experience with DCS and challenges with families that might be broken, and with that sometimes comes need to grant order of protection. And I'm curious to know from you exactly which ones do you give the most weight when you look at reasons to grant that and your thought process behind that. What does that look like if you were a judge, and why would you rank those criteria in that order before you would make that type of a decision?
For an order of protection, I would look at one, I think you have to look at the history. Is this an isolated event? Whatever the risk is, or whatever is in the complaint as to why you're wanting to have an order of protection. Is it a domestic violence where it's happened multiple times? I would take that into consideration. And I think if you look at if you have it available, I think you would look at the mental health of these individuals, because if they have a history of mental health disease or history of something that would raise the propensity of them violating that or going after somebody absent an order of protection, then I think you need to take that in consideration. Also, you look at under the circumstances, Was there, the reason for the order of protection, was there a firearm involved? Was there a weapon, a knife? Or was it just a physical altercation between the two? And I think you look at the aggressor too. Who was the aggressor? And has that person been the aggressor in past events? Or has it been the other individual? And I would hope that we could, and we see this more often than not, people keep going back to the abuser. One of the things we really need more of, and you get this to the Domestic Violence Center, is more assistance helping. And I say women just because the majority of the victims of domestic violence are women. It's not always the case, but the majority are. They have excellent programs to help them break that bond, because it is an addiction to a certain extent. When you've been in a domestic violence relationship and you've been in that for years, and a lot of times that relationship is learned or from when that person was a child, they witnessed their father beating on their mother or what have you. So that little boy was like, well, it's okay. Nobody stepped in. Nobody did anything. So that's how you treat people. And no one's ever helped them get to the point of, that was wrong. What your parent did to your mother was wrong. We have to break that cycle. It's the same thing with the drug abuse. I can't tell you, I've been doing this long enough now that I see children come in whose parents, they came in as a child and now they're a parent and now they've had a child and that child's come into the state custody because for one reason or another they didn't get the help they needed. There's just a lot of ways to prevent and to address these cycles, and I hope I answered your question.
Commissioner Allen.
Have you had a specific courtroom experience where you had to help manage a situation with a rude or intimidating or possibly even intoxicated person? And can you tell us sort of how you helped manage that situation and how you would do it as a judge?
Yeah, there's been a number of occasions. Common sense would tell you if you have a hearing coming up and you're a plaintiff, respondent, or a litigant, you should come to that hearing sober and not under the influence of drugs. That's what common sense would tell you, but in the areas we practice, common sense doesn't always control. I've had individuals, parents come into court who are kind of falling over, or they get on the stand and their memory's jumping around. And sometimes they're off their actual medication, dealing with any type of bipolar or depression, manic depression, anything that they may have. But a lot of times it's other drugs. And what I'll do is, a lot of times I'll continue the matter. I could take advantage of the situation and just go ahead and go forward with my case. But I think a person has a right to a fair trial, and they have a right to be able to participate. And if they're so intoxicated they can't, then we just, stop the hearing. We would reset it. Usually I don't have to step in and do that because Judge Davenport, the juvenile judge that I practice in front of, she takes that step. She's under that authority. But if I was in the General Sessions position, I would have law enforcement assist that individual. Hopefully they didn't have any weapons. Hope they didn't get any weapons past security. If that happens, then we got another issue.
What if someone was just rude or irrational and difficult to manage in the courtroom and not due to drugs? How would you handle them?
And I guess I'd ask clarification. Are you asking when they're on the stand or prior to taking the stand?
I guess probably either, because in a courtroom you're going to have to deal with both.
I've had people off the stand, parents who I've terminated their parental rights, and they'll stand up and they'll be like, "Well, Mr. Wright, how would you like it if I came and took your children?" And statements like that. I've been threatened by parents, by letter, by voicemail, what have you. I'm sure the Judge Davenport, gets more threats than I do, but I'm taking someone's child away from them. I think it's the equivalent of like a death penalty case where you're sentencing somebody to death or you're sentencing them to life in prison. from a civil standpoint, terminating someone's parental rights and taking that child away forever is probably the most dramatic thing that can ever happen to you. Usually, I don't engage the person. When that person made that statement, I just stayed silent. I let the judge control it because that is her role. It's not my role to engage that person, and it's unprofessional. Now, they've been on the stand and I ask them a question, and they'll ask me a question back. I'll be like, is it true that you used cocaine while you were pregnant with this child? And they'll say yes. And then I'll ask what you think is a common sense question. I'll say, well, did you think that was good for your baby? And sometimes they'll say, well, I don't know, which I don't know how anybody can answer that in this day and time, but they'll say that. And then I'll just go through and say, well, you didn't go to this doctor appointment. Why did you not go? Well, I didn't want DCS to know I was using drugs. Well, that right there, in fact, in a roundabout way, proves my point that you knew you shouldn't be doing this. We have to sometimes file motions to ask parents not to have contact with us just because they threaten my client, the employees of the department. My role as DCS attorney is kind of like representing a corporation. I don't represent one individual. I represent multiple people, Child Protective Services, social service workers, juvenile justice workers. The bad side of that is if I'm not happy with my client, I can't withdraw. I have to keep representing them absent, quitting my job. The upside of that, and I think it's the upside for this as well, is I don't have a practice to close. All I got to do is turn in my resignation. I don't have any conflicts. I don't have any other cases to close over the next few months. If I was to get this appointment, you could swear me in tonight, I could start tomorrow. I have nothing to close. I'll be able to be in court every day of the week, 7 days, 5 days a week, whatever you have.
Other questions? Mr. Phillips.
I've noticed a common thread, at least I think, through your resume, and it talked just a final sentence here. It says a general sessions judge must be able to handle heavy caseloads and yet provide defendants with a fair, impartial, timely resolution to the controversy, criminal, civil, before the court. The common thread that I see is defendants. Tell me what a judge should be considering when it comes to the rights of a victim when it relates to property damage or even personal injury. Would a judge, and would you as a judge, consider someone other than the defendant in the case?
And I would consider the victim's rights. This general sessions position, is my understanding, is going to be over the jail, so it's going to be dealing for the most part with criminal, but it also helps out the other general sessions judges that do deal with those issues. I think you have to consider that victim, and I've done so in my practice as well, because one of the big differences between the area of law I practice and what most people practice up here in the courthouse in the square is, in that courthouse, it's usually 2 attorneys. When I'm practicing down there, sometimes there'll be 3 different children, and each of their interests are different, or they can't be around each other because they've sexually abused on one another or perpetrated. They all have their separate guardian ad litems. And then you have mom's attorney, and you have dad's attorney, and then I have trials where I have 6 attorneys at one time. I always take into consideration that child. I don't represent that child. The guardian ad litem does, but I take that child into consideration. That child is the true victim of all of that. The parents created that situation. Do I feel for the parents too? Yes, I was a parent's attorney. I fought for parents tooth and nail. Sometimes it turned my stomach. I've represented parents who were accused of sexually abusing their own child. And I didn't enjoy doing that, but I had an ethical responsibility to do it, and I did. And I carried out that responsibility. I would do the same thing in this position as a general sessions judge, but I think you have to take into account those victims, especially in domestic violence, as we were speaking over here, and also victims of property damage. But I think there's other alternatives to financial restitution sometimes. because a lot of these people who live on the streets or who, steal to buy drugs, you might be able to get restitution through community service or having them go help a church or help this organization, things of that nature. It just depends. I think you look at what's within your discretion as a judge, and you can mold that to a certain degree. Now, there's certain situations where you can't. There's certain situations where the law is what it is, and you have to follow that, and you have to enforce it whether you agree with it or you don't. And that's the oath you take.
Are there additional questions? Okay, then, thank you, Mr. Wright. You may return to the sequestering room, and we'll be in touch with you guys shortly. We got to go through this process that says what's next. We have to give you guys first an opportunity to call any of them back or all of them back for additional questions. Then the nomination has to be done by roll call vote. All right, ladies and gentlemen, we've heard from all 5 of the qualified candidates. There is one more opportunity in this process that we've outlined. If you have additional questions that you wish to ask these qualified candidates, we can bring them back in one at a time again for your any follow-up questions that you think you want to make or choose to make. So first of all, do you want to do that? Does any of you wish to bring these group back in for additional questions? No one has indicated that, so we'll move on to the next step. There are no follow-up questions we're going to have. So now, item F under our policy there says each commissioner by roll call will be given the opportunity to nominate one qualified candidate for appointment. And you can say whatever you want to, or you can say nothing except I nominate the person's name. A second is not required. And still at this time there's no deliberate. You should not make a statement that's deliberating toward a conclusion, okay? So we're ready to have a roll call vote here. And Mr. Phillips.
A particular question. I think when we were doing the sheriff a year or so ago, we looked at going through that process. And if a candidate has already been nominated, should that candidate be nominated again? It actually ends up being kind of a roll call as to how the vote's going to go. So I'm just wondering, is it appropriate? Or should we or shouldn't we nominate someone more than once?
Well, I don't remember exactly what we did, but without objection, the chair is going to say after one person nominates a person, that person should not be nominated again. When we get the first 5 people individually named, we have, if you choose to nominate all 5 of them, that's the end of that nomination process. All right. Mr. Gurley.
Have we reached a conclusion on the voting?
Well, they're still looking at information. So they need a break? I can tell you what little I've been able to watch what they're doing. There are multiple state statutes that apply. There's Robert's Rules of Order, and there's a Commissioner's Handbook. Now, how they've been able to reconcile all of those at this moment, I don't know. So we'll take a 5-minute break, and they're going to have to come to a conclusion here. Okay, ladies and gentlemen, it's time for us to reconvene this session after a brief recess. Now, we are going to give a report on how many votes it's going to take for us to select a General Session Judge Part 2. And there's an extensive amount of research been done here, and but we've come to a reasonable conclusion. Mr. Hudson, will you please review this and explain to them a bit of this quandary we've been in and where we have landed on what we think is the right thing to do?
Well, as you might expect,
Get him up there.
any of this is not as simple as it first appears, but after looking at this, there are some state statutes that are involved, and the one that we believe is on point is voting. It's under TCA 5-5-109. It basically talks specifically about this body or a body, a county legislative body electing an official to a position. Notes that a majority of all the members constituting the county legislative body, and not merely a majority of the quorum, shall be required to elect county officials required by law to be elected by that body. So I believe it would appear that you would need a majority of the body, which would be 11.
So that's your opinion?
Yes, sir.
But let that be reflected in our record here, Mr. Clerk. 11, it's going to take 11 votes to choose this official. That's a requirement for you to elect this commission. That's a controlling document. We won't go into the other nuances that say other things. All right. First thing we have to do is see how many folks are going to be nominated here, and we're going to start, we'll let you start first in this particular case, Mr. Schaefer. If you don't want to nominate somebody, just pass and let the next person take. This is all we're doing. You have to just stand up and nominate a person if you so choose. If you don't choose, keep your seat and move on.
Well, what I was going to ask a question, but I was going to say, can we not just up and nominate all 5 and vote on one?
No, sir. This says that we have to have a roll call vote. This is your policies that we've adopted.
Okay. Well, Mr. Bennett.
Nominated Mr. Bennett. All right. Mr. Piercy, do you care to nominate anyone?
I would like to nominate Mr. Oliver.
Right. Mr. Jordan. Pass. Mr. P. Pass. Ms. Cook. Pass. Mr. Jernigan, do you wish to nominate someone?
I nominate Gary Patton.
Patton. Mr. Cush. Mr. Howard. And Mr. Reed. Pass. Mr. Gurley. Mr. Turner.
Pass.
Ms. Allen. And Mr. Stevens is not in on this discussion. Mr. Johnson.
Pass.
Mr. Baum.
Pass.
Mr. Nipper.
Pass.
Mr. Dodd.
Pass.
Mr. Phillips.
Everyone from Mr. Wright been nominated? Nominate Mr. Wright.
All right. All 5 candidates have now been nominated. We don't need any further roll call vote there. Now, all of the candidates were nominated. So is there any additional questions? You got one more bite at this apple. If you want to ask someone a question, we'll have to bring them all back in. If not, we're going to bring all the candidates back in, and then we're going to vote. Well, let me read this again myself, please, okay? Prior to bringing in nominated candidates, the commissioners will be asked if they have any additional questions. We don't have any additional questions. If there are no additional questions, the nominated candidates will be invited to the courtroom for the deliberation process. They're going to be in here. All right. Is there any other? Sir?
Is there deliberation? I mean,
there has been no
are we ready to vote? And if they're ready to vote, we leave them in the room, I thought.
But voting is just part of the deliberation process. All right. Where is Ms. Stevenson? In the cloakroom. Ms. Stevenson, bring all the candidates back in.
It's going to be hard to leave.
Mrs. Clerk, you have multiple scorecards available, right? And Mr.
Yes.
Clerk, Okay. All righty, are all of the candidates in the room here? So we're ready to vote? All right, we're going to do this differently. I told you we're going to use a little bit of discretion so we don't follow the same procedure and lock everybody else into the always first or always last voting. So, Madam Clerk, call the roll alphabetically.
Commissioner Allen?
For the record, I always go first when it's alphabetical. I am going to vote for Mr. Oliver.
Commissioner Baum?
Chris Oliver.
Commissioner Cook? Commissioner Dodd? Commissioner Ely?
Bennett.
Commissioner Gooch?
Howard.
Commissioner Gurley? Commissioner Jernigan? Patton. Commissioner Johnson?
Oliver.
Commissioner Jordan?
Bennett.
Commissioner Cush? Commissioner McAdoo?
He's not participating.
Commissioner Nieper.
Bennett.
Commissioner Piercy?
Bennett.
Commissioner P? Commissioner Phillips? Commissioner Reed?
Oliver.
Commissioner Schaefer? Commissioner Sereno?
Bennett.
Commissioner Turner?
Oliver.
Two vote getters, Bennett with 8 and Oliver with 9.
And from our deliberation process rules, After each vote, the candidates with the lowest number of votes will be removed from the list for the next round of votes. That being the case, Howard, Patton, and Wright will be not in the next round of voting. Mr. Oliver and Mr. Bennett are in the next round of voting. Okay. Now, any of you that wish to stand up and say what you wish on behalf of your candidate, you can still do that before we vote, but as soon as we allow a bit of that, we're going to have the next round of voting. Mr. Dodd is standing.
And I'm standing not to necessarily advocate for anyone because I'm torn. I know I did indeed vote that last go-around, so I'd like to hear the wisdom of this body. I recall with the sheriff conversation we had, the analogy of the spot on the floor that somebody that's there every day can't see, but you need somebody that knows where the bucket is and the mop. I'm torn over the vigor of youth, a new set of eyes, a young man who could come in and draw some newer conclusions, maybe more progressive, maybe who knows what. And then we have a candidate that's very qualified, that's had years and years in law enforcement and years in the court. So I'm eager. I just want to encourage this board, this group to speak, advocate for your person. I, for one, am flexible because we have two good candidates. So please don't hesitate to speak for or against these folks, at least for my behalf.
Right, any other one wish to make a statement? Mr. Reed, please.
Mr. Chairman, I think when we are trying to make this decision, and as Mr. Dodd has said back there, we're looking for someone who's going to come in here in this position right here that's going to come in with some determination and confidence in what they've got to do. I voted for Chris Oliver, and I did it for a particular reason. Mr. Oliver comes from a part of this state known as Pleasant Shade. For 9.5 years, I worked the Upper Cumberland area for Tennessee Farm Bureau in that area up there, known as the Upper Cumberland. I know that area. I know Pleasant Shade, and I know the people that come from that area. And when you talk about determination, that seems to be bred in those individuals up there. It's located there on the Cumberland River, and when you look back at the resume of this young man, you see that when he left high school, he went about making his way in the world. I don't know how many of you, when you left high school, got you a ton truck and went out hauling river gravel for farmers. But he did that to pay his way through school. And then to get through law school, he started taking shingles off of roofs down here in Nashville. Determination. And then when he wanted to be law clerk for the job here, he showed up here one hot summer day. He didn't even have the dark suit to come for the interview. He had to call his brother up and ask to borrow his suit to come here for that day. He has served in that position, and he has been an attorney here in this town and is a part of a established law firm. And I think that's what I see in this individual, is the determination and confidence to do the job. Now, yes, he's a little less than half my age. Now, I have to say that. But you know, somewhere down the line, I was that at one time, and somebody gave me that opportunity. And I guess the reason I like Chris Oliver is he reminds me of a young man I knew several years ago that didn't have the money to go to school and had to do some of these same things right here, and had some determination to stay in there and do the things he wanted to do too. So I think this is the type of individual I see that would be important to be our next judge.
Commissioner Kush.
Thank you. Thank you, Commissioner. I too supported Mr. Oliver. Two things. He, in his resume here, has been over 5 years already in this court, as he stated, on a daily or at least weekly basis. And also, too, and to me this is very important, he did not apply for this position. He did not apply for the circuit court position. He wanted to only apply from the criminal general sessions judge, which means he is not using this as a stepping stone to become a circuit court judge. That's big. You should think about that. This young man wants to stay in this position for a while. He is not using this to advance himself to the next level. He also references the fact that he understands this position is moving to the jail, where he has worked with Lisa Ishod, which we appointed last year, or 2 years ago, I can't remember, time flies. And he gives her high kudos here. And we all know that Lisa is doing great things there, and she would be a fantastic mentor for Mr. Oliver. And this is a young man, as Pettis has clearly shown, that has the gumption, really is a self-made man at a young age, and has the desire to hold this position for a long time. So his document that he handed out has got some real meat to it. The other one, to me, is a one-page, a little bit of fluff piece. So I would encourage you to relook at Mr. Oliver and think of the future that he would have and he would give us in the General Sessions Judge appointment.
Mr. Johnson.
I also would urge you to vote for Mr. Oliver. I'm very impressed with his humility and the fact that he realizes his age. He's 31 years of age. And I would urge you not to hold that against him, because I can relate. At the age of 23, someone was willing to take a chance on me in my home county of Sequatchie County. I was appointed as the chief deputy sheriff of that county, strapping a gun on a 23-year-old. And they were willing to take a chance on me, and I appreciate that. And I think he realizes his situation, and I would urge you to support him also.
Mr. Gurley.
Yes, I voted for Mr. Bennett because I think he has more real-world experience. I think, Ecclesiastes says there's a time for everything. And I think I admire Mr. Oliver. I talked to him on the phone. I think he's got a great story. I just really don't think he's seen enough of the legal world yet and what he's got to be dealing with. And for that reason, I think right now Mr. Bennett would be a better choice as far as judge. I think, I don't know that anyone would just apply for the circuit court judge and be appointed to it. That's very unlikely with not being a judge prior. So I think he could have applied for it, but I don't think he would ever been considered, because I think, almost always you're looking for someone who's had prior judicial experience. So for that reason, I voted for Mr. Bennett. I really think he's a a great choice. He's a longtime resident of this county. And I, too, have been to Pleasant Shade. It's a great part of the country. Carthage, Hartsville, that's where I was born in McFarland Hospital, but my parents were living in Hartsville, which is right down the road from Pleasant Shade. So I love the people there.
Anyone else wish to speak? Commissioner P. Oh, excuse me. You want to yield to him? I'm sorry.
Well, I voted for Chris Oliver, and to tell you the truth, the two candidates that we're voting on now were my two choices, kind of like in the sheriff's race that we did here a while back. But I've got a lot of respect for Ben. He's a great guy, and he's got experience, but so does Chris. You know, yes, he's young, but having spoke to his former boss, former Judge Lowry, this man is capable of doing the job. He knows the job. He's helped set up these dockets. You know, you've got somebody that can transition straight into the job. You know, he has that experience. And, you know, I think that's enough said. If you sit back and read that resume that he's put out and have a short conversation with some of these guys, I think that he stands out, or at least he does for me. Thank you.
Mr. Turner.
Thank you, Mayor Burgess. I think Mr. P touched on it, that we've got two outstanding candidates that are moving forward, that Rutherford County is going to be lucky either way this vote goes, and we're very fortunate to have Mr. Bennett, Mr. Oliver up for consideration. The reason I wanted to stand up too, Mr. Chairman, was anytime I vote, I always feel like I owe my constituents an answer about why I voted a certain way. Commissioner Dodd, I respect him tremendously, and he was asking, you know, to advocate for your candidate, and that's what I want to do. I voted for Mr. Oliver too. I've never met Chris Oliver. This is probably the first time that he's ever seen me, and it's the first time that I've ever seen him in public that I can recall. But a couple things stuck out to me, and Commissioner Cush touched on one of them, was that not only was he just applying for this is the one that he wanted. And that matters to me, that you're going for something that you want. That I know Commissioner Gurley mentioned that he might not have been eligible to seek the other judge position. But that matters to me when somebody says this is something I'm looking to do, and I'm looking to do that long term. Doesn't mean that career aspirations won't take hold down the road, but I thought that was important to me. The other thing that he said that I appreciated in his written statement was that he's not there as a judge to advocate for anyone. He's there to listen to everyone and make the right decision based on what the law tells him to do and what he believes is the right thing to do based on what the law allows. I think that matters probably more than anything. As he touched on a little bit, that integrity is important to him as it is to all of us, but especially when you're sitting in the role of a judge. You literally dictate someone's life moving forward, and you've got that power, and with that great power needs to come great responsibility, but just as importantly, great humility. None of us are as important as we think sometimes as elected officials or positions that we've been granted. I like hearing about humility from candidates, and that's not to say that Mr. Bennett or any others are not humble. They are. I'm sure they are, and all would be well above adequate to fit this position. But Mr. Oliver, as I was doing my research and talking to individuals that had worked with him, spoke very highly of him. People that I valued their opinion spoke very highly of him and shared with me why they felt like he would be an excellent judge for Rutherford County. And then finally, you know, we talk about age and youth and things like that. I think sometimes we use that as a crutch to say, well, they're just not ready. That might be the case. That's not always a crutch. But I look at experience as well. You know, King David was very young when he was pulled from a pasture. And I find it hard to believe sometimes that somebody would say, I'm 42 years old. And if I have someone that I'm working with that served 3 tours of duty in Iraq and they're 25, I can promise you they've experienced life. That's not, I don't think, what we're talking about here. We can't just look at age as saying, well, they're just not quite ready for that, because there's some 25-year-olds that have seen a lot more about life than I have. So, again, just to circle back to why I voted that way, I wanted people to hear on the commission to know that, and I wanted my constituents to know why I voted that. I'm very comfortable supporting Mr. Oliver in this position. Those are just 3 of the reasons why I supported him, so I hope you take that up in your consideration on the next round of voting. Thank you, Mr. Chairman.
Anyone else wish to speak before we vote? Commissioner Piercy.
Both of these gentlemen reside in my district. I was going to nominate Mr. Bennett. Of course, Mr. Schaefer here beat me to that, so I passed on and nominated Mr. Oliver. But neither here or there. I think we need to make this decision on what we have seen at the podium tonight, not on comments made by other commissioners about why they voted or what they thought the other one did wrong or right. I think Mr. Bennett showed more confidence in his presentation than any other 5 people that were here, and that's the reason I voted for Mr. Bennett. Thank you.
Other one wishing to speak? Commissioner Phillips.
I think we had 5 pretty good candidates, and the decision was not an easy one to reach, and I was glad that all of them were nominated from the floor. My mind wasn't made up until we began the roll call vote. Mr. Oliver was, as a young man, that I'd be proud to call a son. Seems to be the type of young man that we need in leadership positions going forward. I voted for Mr. Bennett, and let me tell you why. The only difference was to kind of piggyback on what Steve said. He did the best job up there. He was prepared. He never looked at notes. When someone asked him for an example, he gave an example. The life lessons that this guy has learned through this whole process of being a sheriff's deputy, working his way through school, working his way through college, working his way through law school, and now standing before us wanting to represent our community after serving all of these life lessons. That was the difference to me. If you want to vote for Mr. Oliver, I have no problems with that. I think he will make a great judge. But I also think that Mr. Bennett will make a great judge. Look how he's ascended, and he's done that simply because, in my mind, he likes where he is, and he wants to continue that process at a greater level. So that's the only reason that I voted for him, probably over Mr. Oliver, but I do believe if you voted for Mr. Oliver, you didn't vote incorrectly. But the reason that I voted for Mr. Bennett, because he did the best job up there. He never stumbled once, he never referred to notes, and he answered your questions and your questions without hesitation or reservation. He gave you examples of everything that you asked for, 100% correctly, I thought. And I think that's important, and I think that's what we need from a judge. I do, I really do, that can render decisions and not be unprepared for those intangibles that might come up. Mr. Bennett, I think, will make a great judge. And I also think that Mr. Oliver one day will make a great judge. So I'm not asking you to change your vote or anything else, but the reason that I vote was a lot like what Steve just said. I think he was the most prepared for this. If you look at who worked harder, I think Mr. Oliver worked harder. He had a lot of information that he descended to us as commissioners, and he's become a favorite, it looks like, of this commission. Once again, I don't think you can go wrong. I voted for Mr. Bennett, and I'll vote for Mr. Bennett again.
Thank you, Commissioner Phillips. That was very persuasive. And Commissioner Piercy, I concur.
Any further discussion? Are we ready to vote? Commissioner Allen.
If you didn't know who you're going to vote for, when I'm done talking, you're still not going to know. I didn't know who I was going to say until they called my name, and I didn't expect it to be first out of the gate, so I wasn't quite sure what I was going to say, honestly. We're in a situation of what I call an abundance of riches. There's not a wrong vote here. I think so many of the accolades that you say about one of these candidates very equally applies to the other candidate. My decision really came down to the very specific experience that Mr. Oliver had in this courtroom. I weigh heavily on life experience. You know, that was, until he demonstrated that, you know, Ben, of course, would have been my guy. So I'm just saying, I don't think there's a wrong vote here. It's a fraction, it's a hairline decision. It's not an easy one, but I'd much rather be in this situation and have too much talent and have a tough decision than to be the reverse.
I don't see anyone else wishing to speak. So here's the next creative voting process. We start with Commissioner 13, and we go through Commissioner 21. Roll call, then we go back to Commissioner 11, because Mr. Stevens is not into this, and we go down to 1. So Madam Clerk, will you call the roll in that order?
Commissioner Johnson,
Oliver.
Commissioner Baum,
Chris Oliver.
Commissioner Nipper,
Bennett.
Commissioner Dodd,
Bennett.
Commissioner Phillips, Commissioner Ely,
Bennett.
Commissioner Gooch,
Chris Oliver with a K.
Commissioner Sereno,
Bennett.
Commissioner Allen,
Oliver.
Commissioner Turner,
Oliver.
Commissioner Gurley,
Bennett.
Commissioner Reed,
Chris Oliver.
Commissioner Cush, Commissioner Jernigan, Commissioner Cook, Commissioner P, Commissioner Jordan, Commissioner Piercy,
Bennett.
Schaefer.
Yeah.
Bennett 10, Oliver 9.
Well, Bennett 10, Oliver 9. A vote of 11 is required to select a judge. We'll have to continue this process until we get 11 votes. Mr. Schaefer.
Do we drop the low one?
Well, if you drop the lowest, you still only have 10 votes. It takes 10 votes. Sir? Oh, me. Roger, you didn't know you was going to get into this, did you? Well, it says after each vote, the candidates with the lowest number of votes will be removed from the list. Whew. We never dreamed it would be this close, did we? So I have to drop Oliver. According to the technical terms of this process, what choice do we have? We don't have a choice. So I'm going to have to rule on that unless somebody wants to call my hand on it. That's what it says. I have no choice. By the technical terms contained in the policies and procedures that you guys approved, I have no choice except to drop Oliver from the voting list.
Well, then why didn't we do that on the round before?
We did, we dropped off, we dropped,
We dropped them all to the one that had the most votes the round before, because we still had Reese 11. You should have dropped Bennett the round before, because he didn't have 11 votes. Well, we got to vote again now, we still have Reese 11. What's the difference? You either drop the round before, or you keep voting.
oh my goodness. Well, it was 9 for Oliver, 8 for Bennett, 1 each for Howard and Patton, and 0 for, wait. Let's let's say everything we're going to say so everybody can hear it.
How many votes in the round previous did you have for Bennett and for Oliver? Was that
Yeah,
five?
no, it wasn't tied. It was 9 and 8.
And Oliver had 9. So who you gonna drop? You gonna drop everybody but Oliver on the round before?
Well, a great question. I don't know the answer.
There were two votes cast in that ballot.
What? Wait just a minute, excuse me.
There were 2 votes cast in that ballot, not for Oliver Bennett. Yeah, they could have gone either.
You can't have a vote.
Well, I may have just completely erred there, okay? We did have 2 votes that were not for Oliver and Bennett, and if those 2 votes had potentially switched, we would have had 11 votes this go-round if they'd have gone both for Oliver, which they didn't. Okay, all of you legal eagles out there, we're in a quandary, and I'm not going to say that I know exactly what we should do. Mr. Turner.
I was just going to say, you kind of beat me to that. I think to Commissioner Cush's point, I'm not sure how Mr. Oliver can win one round and all of a sudden he's out on the next one. But the other question I was going to ask maybe for Roger was, I want to get this right. So do we need to stay in session, or can we take a break so we can make a legal decision here? Because I think Mayor Burgess, you nailed it. I'm not sure anybody knew it was going to be this close, but I want to make sure that I get this right and that we as a commission body get this right, where it doesn't come back and bite us, where somehow we were out of line on what we did or what we needed to do to be legally sound. Do we need to take a break, or what do we need to do?
Let's ask another question too, maybe. First of all, these are your rules. And if I've misinterpreted your rules, you can tell me that. If you want to change your rules and decide what this next steps to be, that's the commission, I still think, has full authority to do whatever you want to. So if I misstepped before and you want us to go all the way back and start all the way over and change the rules, you can do whatever you choose. You're the commission. Mr. Jordan, do you want to say something?
Well, I think we have to stay here and argue this out till it's settled. I don't think we just call it right now. We might have messed up a little bit earlier when we eliminated the 2 with 1 vote apiece, because technically it said eliminate 1. But they both had 1 vote. Common sense said go to the 2 that are the obvious 2. But I say we stay here all night if it takes it until we get 11 votes for one or the other. It isn't fair to either one of them just say one's got more than the other. That's one reason I asked that question an hour and a half ago, because I was afraid it was going to come down to this with 9 people voting. It's a little tougher to get 11. With that said, I would like to see the 2 that have the votes, in my opinion, leave them in the room and let them come up one at a time and make their case again. Give them 3 minutes, 5 minutes, or whatever, and see if they can sway somebody to vote for them, and let them have one last pass. This is a major decision. This is a life-changing decision for that person, and something that's going to affect this county for a long time to come, and we need to make sure we get this right. And I'd like to go home and eat dinner, but hey, if we need to stay here another hour or two, let's work this out. But I don't think we can just call it with 10 and 9 and say the one with the least votes is out. So I would like to see us argue this out.
Are you making a motion to that effect?
Sure. Yes, sir. I'll make a
I
motion.
second that motion.
Just a moment, do we have a second?
Yes.
Several seconds. The motion, as I understand it, is to allow the two candidates, Mr. Oliver and Mr. Bennett, to come back up and give them 3 minutes or whatever you want to give them to plead their case, and then we'll take another vote on those two.
Would that be questions, or just let them 3 minutes and no questions?
I would let them make what I envision, let them come up and make and state their case again, basically, and then give us the opportunity to argue amongst ourselves some more. If somebody wants to get up and say, I like Ben Bennett because of this, or I like Chris Oliver because of this. If we want to go down that path again, let everybody have an opportunity. But I don't think we need to get into each one of 19 commissioners asking each candidate a question, but I would just give them an opportunity.
So the motion is to let both of them plead their case again, and they'll sit down and you guys will deliberate among yourselves before the next vote. That's the motion on the table. Mr. Gurley, did you want to say something? You okay with that? Mr. Phillips?
Thank you, Mayor Burgess. I might have missed something, but didn't you make a ruling?
Well, I made a ruling, but you guys have the opportunity to overrule my ruling anytime you so choose, and y'all have done that with this motion that's on the table, which I don't think is unreasonable at all.
I understand the dilemma that we're in. It's a 50-50 call. It really is. And I'm not sure how we get out of it. But if there are rules that we had and we're not following those rules, I think it's a shame that we're changing them as we're going through this process. If we had rules and you made a ruling, I think that's the way it ought to stand. I wasn't real happy when we did the sheriff. If you guys will remember when we went through the first one, Dale Armour had the most votes. He was 1 vote short. But we ended up electing somebody else. So it's not a lot of difference in that one than it was this one here. I'm just wondering if you made a ruling, shouldn't that ruling stand? And if not, I don't understand the logic. I know Commissioner Cush said something, but I'm not sure I followed it to the...
Well, it appears technically that on that first round, I should have only eliminated the person with no votes. That was the fewest number, instead of eliminating that person plus the 2 with only 1 vote.
Well, isn't that the proper way to do it? To go back and do that again? Just do it like that? Follow the procedure.
Well, if all of you agree with me that I should have only eliminated the 1 person, since there was only 1 person with the fewest, a 0. Mr. Cooch, does that make sense? And then we would vote on the 4 of them again, and then eliminate only the 1 of the lowest on that round. Assuming I'm the one that created this problem there.
What if you still wind up with 2 people who's going to vote against?
No, but we don't know what will happen on the next round. Had I only eliminated the person with no votes, then you take the vote again, and maybe the next time it might have been different, okay? Mr. P. and Mr. Schaefer, y'all can choose.
I just want to say, we got a motion and a second on the floor.
I know we have
got
to
to do
act on that
something with
first.
that.
We have to take action on that motion. Mr. P.
And I agree that we need to move on this motion, but as far as your original rules go and dropping the person with the lowest numbers, I think you used common sense when we dropped the 3. And yes, I see that common sense may have came back and bit us. But the ideal was to get down to 2 candidates. And the main idea is to get 1 candidate with 11 votes. And we don't have that. But we still have 2 candidates with the possibility of getting 11 votes. And I think that this motion will take care of that problem if we give these guys a chance to stand up in front of us and voice why they think they would make the best judge for us.
All right, so Mr. Gurley? Call for the question. All in favor of the question? Opposed? That's more than 2/3, so, all right. Ready to vote on this motion. I guess best we do this by roll call vote, so please cast your vote on this motion. Allow the two candidates to come back and make their case, and then we'll have another vote on those two. So, Madam Clerk, please call the, please cast your votes. And Mr. Jernigan, you need to push yours again there. There you go.
Anyone that did not vote and wishes to vote, or anyone who would like to change your vote, you may do so now.
Okay, record the votes, please.
18 yes, 1 no, 2 abstain. Motion passes.
Right. All right. Well, now, which order are we going to let these people go? Flip a coin. Who's got a coin? I don't carry any coins except in my car. Nobody got a coin?
I got one.
I got one. Penny.
All right.
Mayor, just something, a little bit of humor, if you want. In the state of Virginia, recently, for U.S. congressman, a Democrat and a Republican tied in a special election. They drew a name out of a hat, no lie.
All right. Now, Mr. Spence, I'm going to let you do this. Mr. Bennett, if this comes up heads, it's you. So sit down now. If it comes up, you go first. If it comes up tails, Mr. Oliver goes first. So Mr. Spence is going to, you can go back there and so they can see what you're doing if you want to. Flip the coin up. Head, it's heads, Mr. Bennett comes first. If it's tails, Mr. Oliver. All right, Mr. Bennett, you may come forward and make your comments, and Miss. No, that's not part of the motion. They can hear what each other's saying, whatever. All right, we're going to give you 3 minutes, and we'll have a little grace here if you don't make it in that length of time.
Mr. Mayor, thank you. If I may, let me start by saying 2 things. Number one, I admire very much the input and the thought processes and how everyone is addressing this to make such an important selection for our county. That speaks volumes for this body. It speaks volumes for the individuals representing this county. That's the way it should be. You care about it, and you're up here to demonstrate you care about it by going through this process and getting it right. The second thing is that anyone that votes for Mr. Oliver, their vote is not misplaced. Chris is a fine young man. He's a very fine young man. I've known Chris since he was a clerk with Judge Lowry, and he is a fine man, and he's a fine lawyer, and I agree with you, one day he will be a fine judge. What I would submit to this body that distinguishes us are some of the same things that holds us together. Similar to Chris, I started my life at 18 years old. I had to move out, had to get my own house, had to start working for myself. My first job was a factory in Smyrna. Greer Smyrna is where I worked. When I was 18 years old, went to the unemployment office, said I need a job. They sent me to Smyrna. So I washed parts for 2 years. And I camped out at Truman Jones's door. And much like Commissioner Johnson, someone was kind enough to give me a chance when I was 19 years old to become a law enforcement officer, which was what I wanted to do. I wanted to do that because I wanted to be part of the solution, the same as I've represented to each of you tonight. I wanted to make a difference. I wanted to use those talents that I did have to represent this community and make it better for all of us. And that's the very reason that I have submitted my application for this position, is to do the same thing. It's this county that has allowed me to get to this point. It is my education in this county. It is the relationships that I have built growing up in this county. It is all of those things that give me the unique perspective to see everything that walks into this courtroom from day one. I understand what it's like when that victim is sitting over there, somebody's run over their mailbox and they're out $250. That $250 is important to them. The person that's been stolen from, that restitution, the value of that property is important to them, and I understand that. I stood and took those reports. I understand what it's like to be a victim of that and representing those victims in law enforcement. At the same time, I also understand what it's like from a criminal defense perspective. I know what it's like to be charged with an offense and go to an attorney and say, I need your help. So every time those criminal defense attorneys walk in our courtroom and they say, Your Honor, here's my argument, I appreciate that argument because I am one. I have been one. And I understand what those that are accused, I understand what their positions are. And lastly, I understand what's going to be required of this judge. This judge needs to go in day one and get to work. I think if you ask any of our current judges, they'll tell you the backlog's already getting to them in the general sessions level, and I'm ready to do that. I have presided over these dockets. I have presided over the very dockets that I'm asking you to allow me to continue to preside over. Every single charge, every single situation, everything that this judge will face are things that I have done on thousands of cases, literally thousands of cases as a special appointed judge. And that's what I would like for you to allow me to continue to do. And with that, Mr. Mayor, I'll yield the floor.
Thank you, sir. Mr. Oliver.
Well, I agree with Mr. Bennett. I appreciate the consideration that you're all giving this position. This is an extremely important position. I mean, working in that court for Judge Lowry and Judge McFarland is unreal, the amount of people that come through that court. And it reaches even further than that because those people that come in, they all have a family. They all have a circle that the decisions being made in that court are affecting them all. And you know, sometimes it's tough to talk about yourself and you know, and to you feel like you risk the problem that you're going to come overconfident. But I truly feel like that I very well may have been meant to do a job like this. I feel like that it's easy for me to treat people fairly, and I think that is from my upbringing. I have to think that for the people that I've grown up with and been around with, even since I've been here, I've had the opportunity to be around just tremendous people and tremendous role models, and I've always been a keen observer of that. I think that the amount of time that a person's been on this earth is important. There's no doubt about it. I mean, I have respect for people younger than me, older than me, and I appreciate you all giving that consideration and giving me an opportunity aside from my age. But how we spend our time, you know, on this earth and what's important to us plays a major role as well. And I just believe that I have some characteristics that are going to serve this county well if I'm fortunate enough to be able to serve the county as a general sessions judge. I heard the deliberations. I certainly could have qualified for the civil circuit judge appointment that came out. Governor Haslam appointed a 32-year-old, I believe, earlier this month to sit as a civil circuit judge. That there's no requisite of prior judicial experience for that. And I believe in our neighboring county, he appointed a 35-year-old. But I absolutely understand your concerns regarding my age, because that's a legitimate concern. I would commit to being conscious of it and aware of it. And just like I as a practicing lawyer, As long as you are conscious of it, there are always older lawyers, older judges that may have experienced that one particular thing that you may have some concern about, and you have to have the wherewithal to know to discuss that with somebody. I appreciate so much your consideration for this position and the kind words that have been said about me. It's truly humbling. I would love to have the opportunity to serve in this position. I've been in love with that court since I began working in it over 7 years ago. The fast-paced nature of it, the enormous amount of people that are there, that provides a lot of opportunity to help people. And I thank you so much.
Thank you, sir. Now time for deliberation prior to the next vote. Anyone wish to say anything further? If not, we'll be ready to vote. And again, Madam Clerk, we'll not repeat what we've already done, but here's where we're going to go with this one, unless someone's rising to speak. Start with Commissioner Schaefer, number 1, and go through number 12. Then we go to start back on the back row on Commissioner 21, Mr. Sereno, and go to Mr. Johnson last. So call the roll, please.
Moment, please.
Starting with Mr. Schaefer.
Commissioner Schaefer? Commissioner Piercy? Commissioner Jordan? Commissioner P? Commissioner Cook?
Oliver.
Commissioner Jernigan? Commissioner Cush? Commissioner Reed? Commissioner Gurley? Commissioner Turner? Commissioner Allen? Commissioner Sereno? Commissioner Gooch?
Bennett.
Commissioner Ely? Commissioner Phillips? Commissioner Dodd? Commissioner Nipper? Commissioner Baum? Commissioner Johnson?
I got it. Mr. Bennett, 12 votes, and Mr. Oliver, 7 votes. We do have an 11-vote majority, so congratulations to Mr. Bennett. You will be our new General Sessions judge. Thank you very much. And thank you, Mr. Oliver, and all of our other candidates for your interest and your participation in this process, and we apologize for some of the difficulty that we weren't expecting and prepared for. Thank you very much. All right. We still have one more agenda item, folks. Since it's already this time, it doesn't matter if it's going to take us another 30 minutes. Let's just get it over with, all right? Does anyone desire that we have any recess before we take this next item? I don't think it's going to take an extended length of time. But if you want a bit of time to, I see no one anxious to arise, so let's use your own judgment. This is now, we're going into an executive session regarding potential litigation in the opioid matter. Mr. Turner.
I was just going to say, Mr. Chairman, maybe our recess could be making sure everyone leaves. And
Yeah,
we can
we're
get
going
up and
to
stretch
be
our
sure
legs.
they all are out of here. Yes, sir. Now I see myself on there, so we are live again at the Rutherford County Board of Commissioners meeting. We've had an executive session regarding the opioid crisis. We're back in regular session now, and what we normally do, Mr. Hudson, and you're not prepared for this either, you give a very brief statement on what we have just done during this executive session, if you don't mind.
We've just had a discussion, gentlemen, Mr. Chettis. I'm sorry. Did I do it?
Yeah, you're on.
Mr. Chellis with a law firm about potentially looking into and making an investigation as to whether the county would want to proceed to perhaps entertain a lawsuit as concerns the opioid issue and pharmaceutical companies. And the commission has asked him questions. He's responded. And as I understand the situation, what is up for discussion is whether you want them to make an investigation into this and report to the commission next month.
All right, that being said, we've had this discussion, we've not made any decisions, we've not deliberated, and now is your opportunity as members of the commission to, if you have ideas or suggestions on how we should proceed, you may let us know what they are. Mr. Stevens.
Thank you, Mr. Chairman. I have studied this issue extensively over the past few weeks, and I've seen other counties and municipalities around the country that are filing these lawsuits in federal court against opioid manufacturers and distributors. And the reason that they're doing this is to seek recovery for damages that these places have paid out to deal with the opioid crisis. So all of the counties and cities out there that are plagued with this problem are paying out money for police officers, EMS, jail, incarceration, rehab services. I mean, you name it, the taxpayers are paying out money to deal with this problem. And so I became intrigued with all the lawsuits that were filed, and I started reading some of the complaints, reading some of the articles about the complaints to figure out why these people are all filing these lawsuits. And the more I read about it, the more I studied the issue, the question became to me, why in the world have we not done this yet? I think our costs are going to be substantial if an investigation is done to see where money is paid out to deal with these problems. So I reached out to the law firm that had just recently filed a lawsuit on behalf of Metro Davidson or Nashville, and also Smith County and Scott County, and we had a good conversation about it. And the more of it I've studied this and learned about his firm and the lawsuit that they have filed in federal court, I thought it would be great for us to also consider hiring him to at least investigate to find out what our potential damages might be. I just passed around a resolution a second ago that I'd like to present. And basically, the summary of this resolution is to hire the law firm of Leaf, Cabraser, Hyman, and Bernstein to investigate potential litigation to recover funds expended by the taxpayers of Rutherford County due to the widespread distribution of opioids in and around Rutherford County. So if I may read my resolution, Mr. Chairman, very quickly. It says, whereas the widespread distribution and use of pharmaceutical opioids within and around Rutherford County, Tennessee has become a major public problem. And whereas the taxpayers of Rutherford County, Tennessee have incurred substantial expenses to remedy the negative effects from opioid abuse upon information and belief. And whereas other communities in Middle Tennessee and around the United States have initiated litigation against opioid pharmaceutical manufacturers and distributors to seek damages for costs incurred in combating the issues which stem from widespread distribution and use of pharmaceutical opioids. And whereas the law firm of Leaf, Cabraser, Hyman, and Bernstein, LLP, represents some such communities and is willing to investigate potential litigation to recover funds with respect to Rutherford County, Tennessee, at no cost to Rutherford County. Now therefore be it resolved by the Rutherford County Board of Commissioners that Rutherford County, Tennessee retains Leaf, Cabraser, Hyman, and Bernstein, LLP to be its attorneys to investigate potential litigation to recover funds for Rutherford County as a result of the widespread distribution and use of pharmaceutical opioids within and around Rutherford County. provided that if the Rutherford County Board of Commissioners decides not to pursue claims against any party in connection with the opioid epidemic, Rutherford County will not be obligated to reimburse Leaf, Cabraser, Hyman, and Bernstein LLP for any expenses advanced on behalf of Rutherford County. 2, that the county mayor be and is hereby authorized to execute documents to effectuate the purposes of this resolution. And 3, that any further action, including filing a lawsuit, would require approval by the Rutherford County Board of Commissioners. And Mr. Chairman, I would make that motion.
We have a second. Commissioner Phillips. All right. Discussion. Mr. Gurley.
So this involves only opioids. So it doesn't involve any other drugs, or does this include the poppy manufacturers and growers in Afghanistan, or just the American manufacturers? Just American manufacturers. I just wonder where it stops, because, I mean, you know, drugs change. I think we need to spend our energy finding out what the problem, get at the root of the problem, and providing, trying to find a solution there. You know, opioids cannot be obtained legally except by prescription. And so I'm just not quite sure that this is the right way to go about it, because I think, you know, the drug of choice, I don't know how far back opioids go. I mean, it's always been there. Heroin's an opioid, but it's not a legal one. And so, I mean, you know, how far back do you go? If you're talking about the opioid crisis, that's a moniker that's only been of recent years. I mean, we go back, it was, you know, alcohol, marijuana, methamphetamines, it just, you know, whatever people can get. So, you know, I'm just not 100% comfortable with this.
Other discussion? We got a motion and a second. Ms. Allen?
I have a question. If after this law firm does the investigation, if we decide to retain a different law firm, what will we owe them for this work? Do we know? Because the way it's worded, it sounded to me as if there was, if we did decide to file a claim on the information you provided, it was pretty much on the promise that we would then retain you to represent us. So I'm just trying to make sure, if that is the promise, I just want to be clear about that.
Without objection, we're going to let you speak and answer this. Typically, come up here, please. Motion to suspend the rules, second. All in favor, please say aye. All right.
No, ma'am, you wouldn't owe us any money if you decided not to file a lawsuit or not to file a lawsuit with us.
All right. So you haven't, any other questions or discussions? All right, there being none, I assume you're ready to vote. Well, something this different and important, let's just roll call vote. So please cast your votes. Jernigan, a slight touch to the right, at the right plus. There you go. Thank you.
Anyone that did not vote and wishes to vote, or anyone who would like to change your vote, you may do so now.
Record the votes, please.
18 yes, 1 no. Motion passes.
If any of you wish to have a copy of this resolution, of course, we're going to put it in the minutes, and certainly the clerk wants to have one, but I don't know if Mr. Stevens has, if some of you, he may have a few copies. You already have those copies. I didn't know you had them. Okay. So you already have those, and so if one of you would give that to Mr. Spence, and he'll have that for the record. We've already had any other business. Has anybody thought of something since then? All right, well, thank you very much. I appreciate your participation. We are adjourned.